May it please, Lordship. My lords, having gone through the affidavit filed by the state, we are not pressing this item number 10, my lord, that change of location.
Change of location. Okay.
Yes. Item number 10, my lord.
Mr. Kiran Chaudhary, senior advocate, representing the petitioner, submits that in view of the averments made in the affidavit filed on behalf of the state, his client would be better advised not to proceed with this writ petition in view of the statement so made, the instant PIL is disposed of as withdrawn.
Deeply.
May I please, Your Lordship? I would pray for listing of this PI, Lordship. These were came up for motions, Lordship. I was in another court, Lordship. It was adjourned. And from then on, Lordship, for 1 month, Lordship, no order was passed, so it is hanging, Lordship.
When do you want the listing?
Lordship, on Friday or as per your Lordship's convenience.
Monday. Do it on Monday.
Much obliged.
May I please, Your Lordship?
Yes.
Concern about the other side, my lord, I beg to mention item number 24 and 25 of the daily list, my lord.
Yes.
Some difficulty, it is a part of matter, my lord. Some difficulties on behalf of my senior Mr. P. Mahanta, my lord. I am seeking accommodation only for the day, my lord. Lordship may take it up day after tomorrow, my lord.
Okay. A request is made by council.
My lord,
My lord, on 4th, my lord.
it may be taken on, my lord, 27th or like this, my lord. Because it is part of matter.
On 4th of April, my lord.
Both of you are making the same mention or what?
My lord.
Both of you are mentioning the same
I'm
item.
not mentioning, I'm the petitioner.
I
He
appear from the
requested me
respondent, my lord.
to be prepared because it is only for their argument is left. Because he has given the last chance for arguing the matter. Although, my lord, it may be fixed on, my lord, 28th, my lord.
You are representing the petitioner.
I am for the private respondent, my lord. He is for the petitioner, my lord.
The council, Mr. So-and-so, representing the private respondent, seeks adjournment on account of personal difficulty of the arguing counsel. List
May I appear on 4th of April, my lord. 4th of April.
4th April will not be possible.
My lord, 28th of this month.
28th March, it's a parted matter,
My lord.
Yes, my lord, that is.
parted of this bench,
Yes, my lord.
28th March.
Bless me.
Much
Yes.
obliged.
Yes.
Lordship, as directed by your lordships on 2nd of March,
Yes.
item 39, that the Supreme Court remand matter, pension matter, was fixed on 9th, Lordship. The bench was not available. Today after.
Bench was indeed available.
On 9th, Lordship fixed it on 9th.
So date you
It
took.
is
Mr.
item
Counsel.
39 today.
You took the date, sir.
No,
So far as we remember.
no, I am for the respondent.
What,
That the time.
what do you want today? Now let us. know.
Yes. Today at, as per your lordship's convenience, kindly accommodate at any time.
Today you want the
Yes,
hearing to be
yes.
done.
Yes.
Let us see. Bench is till 1:15. If it
Till
is called up,
115, item 39, very difficult.
we don't know. Have faith, have faith.
Lordship.
Okay,
May I please, your lordship?
yes.
Lordship, I beg for listing of a matter for tomorrow, my lord.
What is the matter, madam?
My lord, the urgency is that, my lord, under section 17(1), my lord, we have filed a petition before of SARFAESI Act before the Honorable DRT on 13th. And the matter was fixed yesterday as item number 1. The Honorable bench is not available and the e-auction is scheduled at 24th, my lord. And the bench is not available till 23rd and supposed to come on 24th, my lord. So
Okay.
this is the urgency, my lord. For tomorrow, my lord.
Get it listed tomorrow. Okay.
Much obliged, my lord. Highly obliged.
Yes.
Lordship, with the consent of other side, I beg to mention item number 8. Kindly adjourn this matter. My senior is out of station for medical treatment.
You are representing the appellant or the respondent?
Respondent
And counsel, Mr. So-and-so,
for EGC.
UGC, associate to Mr. So-and-so, standing counsel, UGC. Praise for time. The other side has no objection. List of 3 weeks,
We will be on 26th of April, Lord.
26th April.
Obliged. Lord.
Yeah.
May I please, Lordship? Lordship, with the consent of others, I beg to mention item number 40, Lordship.
Yes.
Matter kindly adjourned for today, Lordship, and fix after second week of April, Lordship.
Counsel for the appellant has circulated an adjournment slip. The other side has no objection. List for hearing in third week of May. This is orders or hearing?
Hearing, Lordship.
Third week of May. Yes.
Item number 1 for motion.
The TRT.
May I please, your lordship, lordship
Yes.
would be pleased to adjourn the matter for the day because the senior counsel has developed measles. My lord.
Now, this is an unassailable argument, Mr. Nair.
I can't. I can't.
Unsurmountable.
Answer.
Yes. And since they are enjoying interim order, it's all the more convenient. Anyhow, it is stated that Mr. S. Kalita is not well.
Yes,
Arguing counsel, Mr. S. Kalita is not well.
my lord, we have a small prayer, my lord. In the meantime. My lord, till the next listing, my lord, we may be allowed to file our written argument in this,
In which one?
this matter, my lord.
So who has prevented you from doing that?
My lord, we have taken permission.
Who prevented? You need permission.
No bar. File it.
File it and make a mention that you have filed. So we should conclude on the basis of written arguments. What do you want?
My lord, we'll take instructions on that. Till the meantime, we will file a written argument and this court will decide.
Not well. Last date also the same request was made. Interim order shall continue till next date of hearing. Listing. Re-notify on. Mr. Nair.
Monday,
now-
my lord, if not otherwise inconvenient to your lordship.
First week of April.
Measles 7 days.
First week
If
of
they are
April.
29th March.
20.
Interim order.
Fine.
Item number 2 for admission.
May please, your lordship.
Yes.
Well, as per the last order, my lord, they made a respondent made a submission that they will produce the latest supplementary demand made to their government, my lord.
Lordship. The records they have sent, Lordship, but it is in the courier. So may I pray for a daytime, Lordship, 1 day time, Lordship.
Nowadays, the records are received through mail.
Lordship, original records are being sent, that's why, Lordship.
Okay. You are appearing, you are Mr.
RM Das, Standing Council, NC's Autonomous Council.
Well, that may be reflected in the order, my lord.
And Council Mr. Das representing so and so submits that the original record has been transmitted and the receipt thereof is awaited. He prays for short adjournment. List on 30th,
Lordship, yes.
30th March.
Item numbers 3 to 6.
Yes. Yes.
Lordship, I have placed one instruction, Lordship. On last date, your Lordship directed to place a plan, Lordship, for systematic placing of the vendors, Lordship. Lordship, accordingly, they have considered the matter, Lordship, and they are seeking some more time as the process is going on, Lordship. Lordship, may kindly see the letter dated 20th of March.
Yes.
2020.
Have you provided a copy to Petitions Council?
Lordship, I'll provide.
That's necessary. So, Mr. Council, we may give them some time because this is not a very easy task. But if the objective is achieved, it will cause great solace to everyone. Yes, it will, okay, very well. Then at Government Council, Mr. So and so submits that the GMC, authorities in GMC with coordination with other departments are in the process of identifying potential vending zones in terms of this court's order dated 3rd March 2023. Some more time is needed to complete the exercise. As prayed, re-notify on 20th April,
For it, yes, Lord.
20th April,
20th April.
20th,
I'll be out of station. Any other date you're off.
25th,
Lordship, in the first week of May, Lord.
first week May, first week,
That will be coming. No problem.
3rd May.
Right, Lord.
3rd May is a hearing.
Photo me.
Yes, 4th of May.
Item number 7,
Yes.
My lord, there is no stay. We prefer for a stay. That 5 months has already passed. Lane Singhal has said that on the basis of the order that has been passed by the chairman, that they are entitled to get the wages under 6-pay commission. Well, we are agreed by that and we are before this honorable court. Now,
Right.
as there is no stay, my lord, passed by this court and 5 months elapsed. So there are 2 applications which I have filed. One is a stay and another is there's appeal in the urge to argue on the point of law. Your lordship indicated that their law is anytime is open for you. What your lordship said.
Of course.
And so far as the stay is concerned, now your lordship can hear the entire appeal.
Okay.
That's better, I think, my lord, to hear the appeal.
So we may dispose of your IA.
Yes, yes, my lord.
My lord, I appear for the writ petitioners and writ petition respondents number 1 to 14 here in
Okay.
the appeal. Now, I have my objections to the prayer made by my senior colleague,
Prayer for
prayer for stay.
stay is not pressing.
My lord, so we
He is
can,
not pressing.
we can go for, my lord, subject to the convenience of the court for disposal of the.
Every day is a convenient day.
That's what.
Matter is listed, it is a convenient date for us.
My lord.
So we may hear it today.
Absolutely, my lord.
Very well.
Yes,
Mr. Das,
yes.
at loss for words or what?
No, my lord.
Then-
My lord, that's a very small point, my lord. I'll not trouble.
So argue,
Yes, yes, I can argue, my lord.
Yes.
Very small point involved here.
IA not pressed.
I am.
IA number so and so not pressed.
Yes.
Writ appeal, yes.
What is the judgment that has been passed?
Let us read.
That's very important, my lord. What
Yes,
is the judgment that has been passed? At page 127, my lord.
yes. Internal page,
Internal page is. Internal page, kitna hai?
para number.
Yes, para. Para, may kindly see, my lord, at page finding of the court. My lord, at para 9 kindly be.
Then we read para 3 first.
Para 3.
Yes,
That a petitioner council submit the employers other municipal in the state of Assam are all enjoying the pay scale prescribed by the 6-pay commission. And only the petitioner herein are being denied the grant of higher pay scale prescribed by the 6-pay commission on account of letter dated 31/3/2017 issued by the executive officer Tinsukia Municipal Board. He accordingly submit the petitioner should be given the higher pay scale
okay.
as prescribed by the 6-pay commission.
Now please come to para 8 and 9.
Para 8, my lord. Let's read para 8. Now, my para, respondent 5 issued order number dated 23/2017 informing the accountant, Tinsukia Municipal Board, that those employees who have been drawing monthly salary as per the scale of pay prescribed by the 5th pay commission will now be entitled to the scale of pay prescribed by the 6th pay commission with effect from 1/3/2017. Applicable from the 4th grade basic scale onwards, as decided by the resolution number 10 and in the 6th general meeting held on 17/2/17, and the scale of pay was ordered to be prepared accordingly. Subsequently, above order dated 23/2017, the executive officer Tinsukia Municipal Board wrote the impugned letter dated 31/3/2017 to the respondent 5 stating that unless the staffing pattern was not finalized as per the guidelines and direction issued from the Office of Director Municipal Administration Assam and Department of Finance Economic Affairs, any step for salary recruitment in revised pay scale and for promotion to any staff worker would cause gross illegality and be unconstitutional.
So how many decades should they wait before the opinion is received?
I will just show the regulation. Page 47 kindly see the regulation. That's
What
my
ab-
whole case.
What about this observation
They-
in para
they-
8?
Yes, they are not entitled with great respect because of page 47 kindly see my
Mr.
regulation.
Das, this is the resolution drawn by the
Board.
municipal board.
Board.
Yes,
But the chairman cannot take any decision which will be contrary to the Assam Municipal Act.
is this the
37(1).
decision of the chairman?
Yes.
This decision of the chairman
Chairman,
or of the board?
no, chairman cannot take a decision because under my law, there is a provision under statute.
Mr. Das, we are asking you,
Yes.
is this the decision of the chairman in his
Chairman.
individual capacity?
Chairman,
Let us see,
yes.
let us see the resolution.
First kindly see the resolution at page 47, my lord, 47.
Yes,
47.
where is the complete resolution with signatures?
That 48, my lord, in Assamese.
Yes, so does it bear the signatures of
Yes, yes.
all board members?
Uh, Tree. This is the,
Is it your defense? Is it
Yes.
your defense that this resolution was not having the approval of the board? Let us see your pleadings
yes, leading
in the writ petition.
in the writ petition.
Let's see.
Certain points were not taken in the writ petition. That's the whole problem, my lord. I'm telling you very fact. Yes, I know, my lord, your lordship will go by the pleadings in the writ petition.
Obviously,
Yes,
obviously,
yes,
goes
your
without
lordship is
saying.
right. My lord, that's an affidavit we have taken.
And if at all we are committing any error in that regard,
No,
then the
your
remedy
lordship-
lies elsewhere.
No, your lordship is absolutely right, my lord. I am
Yes.
with your lordship, my lord. That's right. We also know. And their case has to be accepted on a basis of pleadings. My lord,
Yes.
affidavit has been filed by us, my lord.
Let us see whether the
Page
affidavit
60.
at any place says that this resolution does not have the
Yes,
approval of the board.
yes.
Yes. How do you explain this resolution in your affidavit?
Yes, my. My lord, para 64 para 6, my lord.
Board meeting.
That the statement made in para 6 of the is misconceived in favorable order from the, in this regard. Board meeting was conveyed on 17 to 2017.
Board meeting, not the
Yes.
chairperson in
No, board
individual
meeting.
capacity.
My lord, hierarchy is a chairman, but board has to be taken into account. Any regulation for taken by the
So
board.
your argument is chairperson was not competent.
Yes,
Now the affidavit says that it is pursuant to the board meeting.
yes.
Then
But, my lord, but anyhow, it is beyond the board resolution which is taken by the chairman. Whether he can take the, some resolution, chairman of the
that is what
independent
we are asking, whether it is the chairman's resolution or the board's
board
resolution.
resolution.
Then what is incompetent about the board?
But, board, kindly see, my lord,
See, read.
statute, kindly see my
Yes.
statute. My lord, only once I will trouble your lordship, it is not inconvenient. Page 47, only for my
Yes.
satisfaction, page 47. 47, my lord.
Yes.
I'll just trouble your lordship with 47.
Yes.
My lord, in your lordship got it. In today's meeting, there has been discussion over the application for increase of monthly salary of Harijan Labor's Employees Office. They were earlier drawing their monthly salary as per pre-revised scale. When all the members wanted to know as to how much more would have to be paid if the monthly salary were to be increased, it was conveyed that if it was given as per Labor Act, then 59,000 more would have to be paid. And if it were given as per the pre-revised scale, the amount of 5 lakhs would have to be paid per month. In this context, the former president said the information required to be taken as whether Dibrugarh, Sibsagar, Jorhat municipal have been paying increased monthly salary or not. After having discussion, all the employees expressed their proposition that instead of regulation, all employees increase monthly salary from grade 4 onwards ought to be paid with effect from month of March. And it was also decided that such benefit should be subject to certain condition. And those employees who violate such condition will be deprived of benefit of increased monthly salary. My lord, there is no denial that we will not pay the amount. We decided. But whether they are entitled to get the 6 pay commission, which has been decided by the chairman independently without.
How do you explain this document at page number 51 in your affidavit? The affidavit is again by the chairman. So are you retracting or what?
I'm sorry.
Are you retracting from that document?
Which the chairman.
51.
Chairman, the
Page
chairman, yes.
51. Read the pleadings, please.
Para 7, my lord,
Yes.
of my affidavit
Yes.
at page 65.
65.
Yes.
Yes.
That is affidavit which you have filed before the learned single judge.
Yes. It's not 65.
Para 7.
Para 7. That would
What
be
you got
it.
it?
Yes.
Basic. That is statement made in para 7 or it is misconceived, misinterpreted in order to gain a favorable order from this honorable court. In this regard, deponent makes the order dated.
Mr. Das,
Yes.
this is not the affidavit. The affidavit it says statements made in para 4B
4B, my lord.
Yes, you read para 7.
I'll read para. That's an affidavit in opposition, my lord. Page 65, my lord.
Affidavit in this appeal.
Opposition, we filed. In the writ petition, my lord, in the writ petition.
Well, that's what I'm reading.
60,
Not 65. Okay, okay. Yes,
para 7, my lord.
yes,
That the statement made in para 7, lordship got it, my lord.
yes.
Of the writ petition is misconceived and misinterpreted in order to gain a favorable order. From this, in this regard, deponent makes an order dated 23/2017 was not for disbursement any enhanced salary as interpreted by the petitioner, but for preparing the bill only. The proposed bill was meant for assessment of the extra amount required to be paid on the existing salary of the temporary casual fourth grade staff workers, and also for placing it before the board for further discussion. Therefore, the order dated 20 is an internal correspondence with the official of the board and was issued for preparation of the bill only and not for disbursement of annual salary as interpreted by the petitioners.
How do you explain the document at page 51, please?
Page 50,
1, annexure 4. What have you said about it?
51, my lord.
Yes.
That this is what I urge. Your lordship is right. Let me understand. Your lordship is absolutely correct. I says something which is not in it. That's why I said, before your lordship, can I urge? This is a ground of law on appeal.
Where is that ground in the appeal?
Appeal, my lord. So
Where is this ground raised in the memo of
and
appeal?
then
They are entitled to counter it.
sure, my lord. Whether
We can allow you, but
Yeah.
there has to be something on record to make in support of this argument.
that's let me put straight away. That is not a part of it.
Yeah.
Let us be, because otherwise only what I take a leave of the court, whether, my lord, whether a chairman, whether you could arrive at a such a decision.
For that purpose, we would have to see the original record of the meeting
Yes, sir.
because translation is not there.
I'm correct, my lord. I can just produce the original record if your lordship wants it.
Let us ask him, what do you say to this
But
argument?
only one thing, if your lordship is not
Please,
inconvenient, my lord.
please.
Only that's your lordship will kindly take this act. Assam Municipal Act 37, my lord.
Yes. 37. Section 37.
37, my lord.
Yes. Yes.
37 powers of chairman. The chairman shall, for the purpose for the transaction or business connected with this act or for the purpose of making any order, authorize that by access all the power vested by this act in the board, provided the chairman shall not exercise any power which shall not be exercised in the rule of such. Now this is provided all the chairman shall not act in opposition to or in contravention of any order of the board at a meeting or exercise any power which is directed to be exercised board at a meeting.
Now please read page annexure 4, page 51.
Annexure?
4, page 51.
That's the resolution, man.
Yeah.
Right.
Not the resolution. The
That's
consequential
the
order.
order.
Now
No,
you are
no,
saying
my
that the order is without jurisdiction.
Yes.
Read
Now-
the order, please.
Now kindly see, my lord, which with a great respect to the learned single judge, kindly see 74, my lord, page 74.
Can we read page
Which
51
you-
first?
51.
Yes.
Yes, I'll read this 51.
Yes.
This is to inform that all the 51, all
Yeah,
the
yeah.
employees who have been drawing monthly salary as per the scale of pay prescribed by the Fifth Pay Commission will now be entitled to scale of pay prescribed by the Sixth Pay Commission with effect from so and so applicable from both grade basic scale and onwards as decided by
As
resolution.
decided by
But-
resolution number so and so.
But regulations,
So this is simply a consequence to the resolution drawn by the board.
right, I
So
do
what is
agree.
wrong about it?
But regulation, I have to see the original. Regulation is contrary to resolution.
Then you will have to have the pleadings
No,
which are lacking.
no, my
Sorry
lord,
to say that. No, no. These are
apparently-
factual pleadings.
No, apparently based on this regulation on 70, it is not, my lord.
Was this the argument before single bench?
My lord, that
Is this the ground in the appeal?
no,
That
but,
this resolution was not recorded in this manner.
but Learned
Please.
Singhal overlooked our affidavit by annexing two documents which were kept in abeyance. The chairman's order was kept in abeyance. At page 74, kindly be seen, my lord.
Who has done that?
That is done by
By
the my lord,
unsigned document.
yes, by the chairman itself,
So subsequent chairman,
chairman itself.
subsequent chairman,
Because when
does the
No,
subsequent chairman has a
same-
power?
the
Then
change,
the question is, does he have power to review the decision of the board?
that's my lord, that has to be, this was brought to notice.
No,
My lord, kindly see page 73, my
we
lord,
have seen it.
73. 31.
Siddharth, tell us, does the chairman have the power to review the decision of board, resolution of board?
But ultimately, my lord, if the decision taken order passed by chairman is contrary to the resolution,
There is no order passed by the chairman. He simply conveys the consequence of the board resolution.
but that board in the country, board didn't
Let
say.
us read your pleadings, sir, again.
Yes,
We are just running around in circles. Read the pleadings of appeal.
now, my lord,
Read this ground in your appeal, sir.
yes, 16, my lord,
Yes,
7.1.
yes.
Though the petitioner contender said order dated 23/2017 was passed pursuant to resolution 10 CHO adopted in 6th general meeting of Tinsukia Municipal Board held on 17/2/2017. Same is incorrect and contrary to record. Resolution, Lordship got it, my lord.
Yes.
Resolution number 10 contains in the minutes of meeting of 6th general meeting does not refer the term 6 pay commission. The said resolution merely provides considering the grievances raised by the contractual employees. The monthly salary of such employees ought to be increased with effect from March 2017, subject to certain conditions. And if an employee violates the condition, then the concerned employee will not be entitled to increased salary.
Yes.
Thus, on the reading of the resolution, it is clear there was no decision taken to confer benefits under the 6 pay commission.
Yes, yes. No.
7 point,
Where is the
Fine.
entire resolution has been translated? Let us see, please.
My lord,
It's your document.
my lord,
Have you provided the complete translation?
my lord, complete translation we did not annex.
Then,
We annexed the relevant part. We.
okay, read the relevant part also. Does it refer to 6 pay commission? That is a page 47.
Page 47.
Read, please.
In today's meeting, there has been a discussion over the application for increase of monthly salaries of the Harijans, the laborers and the employees of the office. They were earlier drawing their salary as per pre-revised scale. When all the members wanted to know as to how much.
Need not
more-
read the entire thing. Read out where it recommends grant of benefits of 6 pay commission.
My lord is, my lord, referring to the exact terminology 6th pay commission.
Yes, obviously.
My lord, this is where this particular part of the resolution, my senior colleague is correct in saying that the term 6th pay commission.
So then
has not
what the chairman conveys by the document annexure 4
My lord,
is beyond the resolution.
my lord, here, subject
And
to-
their argument then
my lord,
has to
subject-
sustain.
subject to correction. My lord. My argument, my limb of argument so far this aspect is concerned.
Yes.
Your lordship will kindly see the very third line. They
Yes.
were earlier drawing their monthly salary as per pre-revised scale.
Pre-revised scale means what?
Basically, my lord, in one of the
Mr.
documents,
Counsel,
my lord,
the argument which is taken is
my lord,
that they are not even public servants
my lord, I'll counter
or
that.
government servants in the strict sense.
My lord, I'll counter that as well.
In that event, what is the revised pay scale for
My
them?
lord, the fact that they were drawing scale as per 5th pay commission is reflected at page 81, my lord.
81. Whose affidavit is this? Whose
My
affidavit?
lord, this is our affidavit, my lord.
This bald argument or averment has to be supported by some document.
My lord, the support and support to this limb of argument, my lord, was these employees were being provided with 12% on basic plus DA, which is the specific, my lord, that is the specific, that is what is specifically provided under the 5th pay scale. Now, this is something, my lord, that they have been urging before the municipal authorities for quite some times that they were being given 5th pay scale. The employees of other municipal boards and municipal corporations,
Council, you have to agree, understand one thing.
my lord,
It is their claim that your clients are not even regularly appointed employees.
my lord,
We don't know the situation regarding the other boards.
my lord.
So how do you draw equality out of that?
My lord, insofar as their argument to the extent that they are not permanent employees or they are not public servants, to that effect, my lord, the provision under section 50 that says that subject to staffing pattern. My lord, the employees are directly appointed by the board and their salary
Better
structures.
course of action into our mind would be for the present, stay the order and direct the state authorities
My lord,
in coordination with the department
my lord,
and the municipality to take a rational decision. We also understand that the employees can't be stuck on the same pay scale for decades
my
together.
lord.
But then it can't be done at the whims of the chairperson.
It can't be done.
It has financial consequences.
My lord. Now, only, my lord, that is something, my lord, that I cannot go beyond whatever is on record apparent. Page 47, colleague has pointed out that this terminology sixth pay commission has not been used.
Then what the chairman conveys
My lord,
is beyond the board's resolution.
but my lord,
It's not a
here,
faithful reproduction.
but in the writ petition,
Then the chairman recalls or puts it in abeyance, that document is not considered.
my lord, in the writ petition, my lord, for a while, if your lordship kindly sees their affidavit in opposition at page 64 and page 65,
Yes,
paragraph number 6 and paragraph number 7.
yes.
My lord, here what they are referring to is that though the decision had been taken to convert the benefits of.
The affidavit of the same chairperson,
Yes,
contrary to the document.
no, now what they are trying to say is,
Resolution doesn't say so.
that is what. Now, this is the round of argument that has come up in the appeal, my lord. This did not come up in the writ petition. This did not come up in the writ petition.
Based on admitted set of documents filed by you.
My lord, that is true.
So then,
But precedent facts, my lord, the antecedent facts are what I am relying upon because we had been representing before the authorities.
all right, that's what we are saying,
My lord,
that let this court give a direction in this appeal. Consider the case, whether it would be feasible as per law to extend these benefits.
my lord, that.
Then you will get a cloak of authority.
Yes, yes, my lord, it can be an interregnum direction keeping the matter pending, my lord.
Yes, of course.
Yes, yes, of course. Yes.
Yes, what do you say? So then we don't dispose of that IA,
My lord.
or on IA number so and so. Mr. Das, senior counsel representing the appellant, urged that the impugned judgment whereby, direction has been given to the municipality, municipal board Tinsukia, to enhance the pay scale of the employees in line of the sixth pay commission on the basis of letter dated 31/3/2017 does not stand to scrutiny. He contended that the letter dated 31/3/2017 was issued by the chairperson. Mention it 31, which is the letter dated 31st March,
31st March is 73,
page 73,
issued by the executive officer, including chairperson.
was issued by the executive officer as a consequence of the purported resolution of the board held in the meeting held on 17/2/2017. Drawing the attention of the court to the minutes of the meeting reproduced at page number 47 of the writ petition, Sudas submitted that no such resolution was drawn by the board that the employees should be extended benefits of the sixth pay commission. It thus urged that the direction given by the learned single judge to extend these benefits to the respondents' writ petitioners is bad in the eyes of law. Full stop. The matter requires consideration. Having regard to the facts and circumstances noted above, it is hereby directed that effect and operation of the impugned order shall remain stayed till disposal of the appeal. Writ appeal, the instant writ appeal has been filed to assail the direction of the learned single judge, whereby, the appellant board was mandated to extend benefits of sixth pay commission to the employee writ petitioners. by a separate order passed in IAS number so and so, comma, we have stayed the effect and operation of the impugned order. However, the fact remains that the employees who are serving the municipal board since years together and were admittedly drawing salary in accordance with the fifth pay scale, comma, cannot be left to stagnate at the same pay scale indefinitely. In this background, comma, the municipal board, in coordination with the, you have not implemented any department of the state government,
Page 4, madam, of the appeal.
in coordination with the urban development department, comma, undertake an exercise to explore the possibility of extending these benefits to the employees of the Tinsukia Municipal Board in line with similar benefits which are perpetually being paid to the employees of other municipal boards. The entire exercise as directed above shall be completed within 6 weeks.
I have a small query, my lord. In place of only urban development, can it be also 16 and 17? Respondents.
Finance Department.
Finance,
Responds
as
number
well
so
as
and so.
Director Municipal.
Finance and Director Municipal Administration.
Deeply open.
Only your lordship will just clarify. If they are entitled sixth pay commission, absolutely no problem. If
Thus,
they are
you are
not
paying
entitled-
them fifth pay commission,
Yes,
then why are they not entitled?
no, I have also.
Have you withdrawn the fifth pay commission?
I- What, we, as per us, my lord. If
We are
they
just
not-
asking you
No,
to
I know,
explore.
They can get, I'm a veto lordship.
Yes.
They should get, they are working for so many years, their salary cannot be cannot be kept stagnant, my lord.
Yes.
But the question whether they get fifth pay commission, if they getting fifth commission, they are also entitled to get sixth pay commission. Your
That's what
lordship
their
is right.
contention is. And this has not been disputed. That was affidavit in rejoinder,
Yes.
wherein the specific plea was taken, which is not disputed. So that situation we can't change.
Deeply.
List of
We'll
6 weeks.
look into it, man.
Sure.
Deeply obliged.
Ultimately, they are your employees.
No, no, it's
It's
sure.
your duty to take care
No.
of their welfare.
My lord is fixing any date after
6 weeks. We'll put a date after. Maybe it will come up on 29th May.
29 of like.
Yeah.
We'll write to the urban department also. Government has to be.
Copy of this order shall be transmitted
Yes.
to the departments concerned for.
Yes.
Deeply.
Deeply
open.
obliged.
For compliance.
Item number 9,
Yes. Yes.
My lord, that IA filed by the Assam Judicial Service Association is before your lordship. My lord, the earlier order, my lord would find at, it starts at page 14, 2/2/2020.
14 of the IA.
Lord. IA number kitna?
No.
MC, my lord, sorry, 18 of 2023.
Why it's coming up before division bench?
My lord, I had made a mention before, my lord, because my lord, the matter was resolved, but it was not taking it to the desired level.
Okay.
My lord, what had happened was the judicial officers' pay slips and the other things are done by the AG.
Mhm.
This was not being done in a proper and timely manner.
Mhm.
So, my lord, they had come up, a sumoto case was registered.
Right.
In that sumoto case, my lord, an undertaking was given by the AG's office that there will be a dedicated email ID wherein the grievances can be put and there will be a cell. But my lord, it seems now, initially there was some
In Rajasthan,
compliance
there is something called a Sampark portal.
portal
There, every complaint
can be.
goes to the chief minister.
Now,
Yes.
now what has happened here, my lord? The
Yes.
Supreme Court has revised the directive for revision of the pay.
Yes.
25% was to be paid within 3 months of the order of the Supreme Court, which was in February
Yes.
2022. Government in the month of December 2022 accepted that.
Mhm.
Options were to be given by the judicial officers. They have given their options. But my lord, we are in the end of March now. My lord, that has not done. He's the one, my lord. He's
Yes.
for the association.
You represent the High Court.
I am a High Court, my lord. For the High Court.
What do you say, Mr. Counsel?
Lordship, that we have not responded, Lordship, that is not true, Lordship. One email ID was opened and accordingly, Lordship, we have.
Should we institute a suo motu contempt then?
No, Lordship, I have received the written instruction, Lordship, for it may be given so that I.
We need the compliance full and final
Lordship,
within next 7 days.
Lordship, we are issuing payslip, Lordship, but that notification
Only 8
after,
payslips have been issued.
Lordship, after notification from the finance.
All right,
department-
suo motu contempt proceedings drawn.
Lordship, I may be.
Finance
allowed-
secretary should be here next date.
Lordship, I may be allowed 7 days time, Lordship, I will file a reply, Lordship.
No ifs and buts.
Lordship, I have received the written instruction, Lordship.
What are the instructions? Mr. Nair, look what the instructions say.
Lordship.
Do they indicate any form of compliance? 31/5/2023. Why does it take so long?
However, copy of the government has been submitted by the presiding officer to the office on 21/12/22. Requesting clarification to implement this or issuing request then, because the provision. My lord, they received it on 21/12, the government of Assam's compliance.
Tomorrow, keep your principal
Lordship,
accountant general
Lordship,
present in the court.
Lordship, one more submission, Lordship.
Yes.
That notification was received by the office on 21/12/2022, Lordship. Thereafter, Lordship, in spite of Lordship, that notification was never forwarded by the government of Assam, Lordship. Only the presiding officer of the labor court had forwarded, Lordship. It has to be come from the government, Lordship. But in
Were
spite
you
of,
represented?
Lordship, in spite.
Were you
in spite of that
represented in the
also-
red court, sir?
Lordship, in spite of that also, Lordship, we issued the revised slips of some.
How can you
officers,
take that argument that the order was not forwarded?
Lordship?
How can you take that argument that the copy of the order was not forwarded? Were you a party in the writ
Lordship,
proceedings?
in this case, Lordship, we have written the letter to the finance
According
department
to the High Court order, my lord, the order passed for
by the.
issuance of the
Payslips.
revised by the government.
By the comment.
Lordship, that letter has to be come from the government, Lord. In spite of that, Lordship, we are issuing the revised pay slip to some officers,
8
Lordship.
officers.
Some.
Yes, Lordship, we are on the, because Lordship, we have to look after the all government related state government issue, Lordship. Moreover,
He's
Lordship,
being
we are
paid salary
taking
for
the
that
matter on
purpose.
priority basis,
The
Lordship.
departmental officers get salary for this purpose.
Lordship, but.
They are paid to do this work.
Lordship, there is some problem.
They're not obliging anyone.
Lordship, I have obliged, yes, Lordship.
7 days time, full compliance, or else keep your PAG present in the court.
Lordship, some clarification from the finance.
7
department,
days.
Lordship, I will tell Lordship. That instruction, for a moment, Lordship, kindly look that instruction, Lordship.
You want
Because
7 days time.
For revise of pay, Lordship, finance department's approval is also required, Lordship.
Well, they have already granted.
No, Lordship, that Lordship clarification that we have visited the office of the finance department also, Lordship, and finance department asks us to forward a letter through official member, Lordship. So, Lordship. according
For
to-
all practical purposes, you are wings of the same government.
My lord,
We are
we'll
not
see the
bothered.
seriousness. My lord, will see the seriousness.
Yes.
My lord, will come to the second page of that instruction.
Yes,
Second paragraph, my lord. If they are so interested, so aggrieved, I have nothing to say.
yes.
However, a copy of the government notification has been submitted by the presiding officer, White Office dated so and so on 21/12/22. On scrutiny of the so and so, this office required some clarification from the implement for issuing revised pay slips to the so and so. Thus, 2 officials from this office has visited the PRE on 3/2/2023. Notification is of 21/12/22. They have not said anything.
And they received it on 21/12.
21/12.
So it takes you 2 months to start acting upon it.
Lordship, 7 days time, Lordship, I'll file a petition.
Full compliance, or else your officer remains present in court. Okay, the net counsel, Mr. So and so, representing the respondent, has placed on record certain communications in compliance issued indicating the steps sought to be taken for compliance of this court's order dated so and so. However, we are not in the least satisfied by the manner in which, the office of the principal accountant general has proceeded with the matter. We grant one more opportunity of 7 days to the PAG Assam for ensuring full compliance of this court's order dated 21/2/2021. The compliance report be placed for the court's consideration on the next date of hearing, following which we shall be compelled to required personal presence of the officer in this court. List on 3rd April. Next.
Item numbers 11 to 23.
Who is the public prosecutor? There has to be reply to that. 389 says it's mandatory. Who is the public prosecutor? You are Mr. Chaudhary? You have to file a formal reply.
Yes, to the bail application.
Yes, 389 says so.
Yes, Lord.
That is mandatory.
My lord is.
Supreme Court has reversed a few orders
My lord.
because reply was not taken.
Your lordship, in this matter, there is a series of matters are there. In this, because of the conviction sentence passed by the special court. Your lordship, there other two bail matters were also been heard. I believe my senior was arguing this matter in Mohit Huzai. Your lordship, that matter is there. Second year, this matter which have been filed, I have earlier filed on two occasions.
On behalf of the same accused.
Same issue.
Okay.
What happened in that? The lordship will kindly see
Hold on.
annexure A.
If just hold on, sir. You say that this is a third application for SOS.
Third application.
So why shouldn't it be indicated in the memo of the application?
My lord, your lordship will see on both the occasions, I have withdrawn it.
Maybe.
Because,
Irrespective thereof,
my lord,
this fact regarding earlier applications,
it has been pleaded. It has been pleaded.
where is it mentioned? Let us see. The note below,
Yes, it has been
there
pleaded.
has to
my
be a
lord.
note below the bail application. Where is it?
Kindly come to my lord, page 11,
Yes,
para 10.
yes.
That the applicant humbly submits that on two earlier occasions, the present applicant has approached this honorable court for suspension of sentence and grant of bail.
Where it is mentioned. Either it is the first bail application, the process bail application in appears. And by that is what we moved is provided. That means that. This should be there. Yes.
My lord, on those two occasions, my lord, if your lordship kindly peruse the order dated 35
Mr.
page.
Counsel, that always happens. You are not getting a favorable order, you seek withdrawal.
No, my lord, the circumstance was different.
What
At that
was?
time, kindly see, come to page 35.
Yes,
Kindly come to page 35.
yes.
The learned
Appeal should be heard.
appeal should be heard
Yes.
within a period of 2 years, my lord. Because other co-accused has appealed before the suspension of sentence in the Supreme Court. The Supreme Court did not entertain it.
Okay.
So they came before the court that let the appeal be heard.
So only man who has been sentenced to life is this accused.
No, my lord, with me, there are other two accused persons are there.
Okay.
Two accused persons.
What is the fate of their bail applications?
My lord, one is the hearing has been going on. If I'm Mohit Huzai's, his bail application has been going on.
In a
Hearing is-
different bench.
My lord,
In which bench?
this bench only. It was heard by earlier.
Lordship was not a part of this bench. It was.
So that bail application is still pending.
Yes, that was filed in 2021.
So we should tag that bail application and hear
It's
the
there,
both.
it's there in item 60. Yes, it's there.
It's listed. Okay.
And my lord, if lordship permit me, this bail application,
Yes,
the earlier bail application was rejected. We went to the Supreme Court.
yes.
Supreme Court said that the appeal be disposed of within 1 year.
Okay.
And then bail matter can be considered, but it was not disposed of, and the bail was also, my lord, second time also it was rejected. Those pleadings are there.
Mhm.
Now, I have completed the hearing during COVID. There
No,
are
that-
7, 8.
That's a thing of past, sir.
my
The
lord.
bench
That's
before.
right, that's right.
So now,
And when I saw that it's not possible because there are 13 matters, 13 arising out of the same judgment.
what is status of bail of other accused persons? How many are on bail? How many are in jail?
3 of us are in jail.
Chart.
All
Is there a
other-
chart?
3 of us are in jail. Others all off. Others are all have been granted.
Only
bail.
these, I think, 3 persons were sentenced to life
Life.
imprisonment.
Yes,
So if your lordship take up my, that bail matter, where is my bail? Yeah.
at serial number
16,
16.
bail application, this IA is 323 of 2021.
Yes. But all the same, we need a formal reply. That is mandate of 389.
In this case, the replace health provision is no.
No, no reply has been filed. This was filed in 2021. No reply has been filed.
You'll have to give him one opportunity. Even if it is so long, still read 389, please.
It was filed mainly on the, after the Southern Singh judgment came. Although before also there were judgments, Kashmira Singh, 77, your lordship will know.
Yes.
Southern Singh came in 2022,
Mhm.
where, my lord, the Supreme Court said that if you have served more than 10 years.
Custodial period. Yes.
Total, and your appeal is not heard, not disposed of, that's the word
Yes.
used. Then the bill should be granted. And an observation. was made.
Please read proviso to section 389.
Provided the appellate court shall, before releasing.
In writing.
Provided the appellate court shall before releasing on bail on his own bond, a convicted person who is convicted in offence punishable with death of imprisonment for life or imprisonment for term not less than 10 years, shall give opportunity to public prosecutor for showing cause in writing against such release, provided further that a case in where a convicted person is released on bail, it shall be open to public prosecutor file an application for
So
cancellation.
it's mandatory. Give him an
Notice as such was issued.
We
But yes,
understand.
they have not filed, they chose not to file.
We have to give him an opportunity in writing, telling him that we are giving you opportunity, file reply if you want. Show cause if you want. Then he doesn't do, then we can proceed. By mentioning that he has chosen not to file, respond. But formality has to be done.
With your lordship's experience, my lord, the chief justice experience, I'll only say that Article 20 cannot be made subject to their whims and fancy, whether they file or they will not file. Once your lordship issues notice.
What we'll do, sir,
That's it.
notice in a criminal case is mandatory otherwise
Yes.
also. But in writing, we'll require them to show cause within a limited period.
I leave it to your lordship. There's no
Yes.
quarrel with that proposition.
Lordship, 2 weeks.
Not 2 weeks, sir. What have you done so long? What took you so long to respond? We'll say that you have not responded despite repeated opportunities. Matter has been argued. This can't be tolerated, sir. Sorry. All right. These two applications under section 389 CRPC. You record a common order in Mohit Ojai and Jayanta. Ajwal Garlosa. 1116. Seeking suspension of sentences awarded to the appellants by the special court. Both the appellants have been sentenced to life imprisonment. As per proviso to section 389 CRPC, it is mandatory to require the public prosecutor to show cause in writing against the prayer for SOS. Thus, in the interest of justice, in spite of the fact that the applications for SOS are pending since long, we grant one last opportunity to Mr. Chaudhary for showing cause in writing to the prayer for suspension of sentences. List on 3rd April. 3rd April. It's a formality, but you have to do it.
Yes.
Many times when you go for filing reply, the antecedents also come in. And the custody certificate, both. If you want, we can provide you a format from Rajasthan. Yes.
Item number 50 of supplementary list for order.
Same day, of course, along with connected matters. This came up from yesterday now. And the rules do not have it that closure. If one of them. Yes. Guiding over the tenure.
My lordship, this is I am for convention of delay, my lord. The 205 days, my lord.
I have checked this ticket. It's okay.
Are you filing any reply for the
Why not?
delay? You not filed any objection? Heard Mr. So-and-so learned counsel for the petitioner and MS so-and-so for the respondent. This application is being filed seeking condonation of delay of 205 days
Right.
in preferring the appeal against the judgment and order dated so-and-so passed in WBC so-and-so.
Hmm.
The learned counsel for the petitioner has referred to paras 4, 5 to submit that because of circumstances beyond the control of the petitioner, there was a delay which occurred in filing the connected appeal. Post of the learned government council also does not object to the prayer made for condonation of delay. No objections have been filed. Having heard learned counsels for the parties, and upon perusal of the application seeking condonation of the delay, we find that the grounds taken for delay have substantially explained, satisfactorily explained the delay that has occurred. We do not find that there is any malice in the there's any malice that can be attributed to the petitioner for the delay that has occurred. Accordingly, this I is allowed, delay also is condoned. I is disposed of, registry is directed to register and list the appeal on a date fixed by the registry.
All right, my lord.
The number 26 of daily list.
May I, Lordship?
Yes.
Lordship, in this matter, actually, Lordship, yesterday night only I got to know from my learned friend that single judge order has been complied with. But I could not contact my department officials. So Lordship, I just pray for a week's accommodation so that I can get the proper instructions. And if that is so, then this is no longer there.
List on 3rd April as jointly prayed. 4th April, 4th
Both of them.
is hearing day.
I prefer some accommodation. Could it be the day after or some other date, my lord?
Day after only.
My lord, yeah, on 5th April or thereafter, my lord.
On 5th April.
My lord, any other day, my lord.
Okay. Let's then have it on 10th April.
Deeply obliged, my lord.
Item number 27.
My lord, of course, some important issues involved, my lord. This has been handed over the brief to me is regarding land acquisition matter. I have to go through it more whether 2013 Act or 2016, whether it's 371G under the statute, constitution or visa inserted for the benefit of Mizo people, my lord. So now there are interpretation of ownership and transfer of land. So I think we should, my lord, it requires some time, my lord, to look into it because the act which is being made by us, whether the learned single judge has gone under 254. What I have looked into it is not a case of 254 because.
Are you prepared to argue it today, sir?
I have to. I made a note for your lordship's convenience. So I can just give it to now itself.
Sure, sure.
So that next time your lordship, when it comes and sit. Or with judgments, I can.
We can give it in.
Next time.
During the course, I'll put some judgments and note which are the
Share it with the
I'll
other
give it
side.
to my learned friend.
Okay.
So when your lordship sits, it'll be easier for your lordship.
Sure. Mr. Das, Senior Counsel, Mr. Nepal, submits that he needs more time to prepare an the matter. List after 6 weeks. What is the IA?
My lord, that is for payment of the interim, as an interim measure, my lord. We have been paid the the compensation under the 2006.
So we can dispose of the IA.
My lord, my lord.
Interlocutory application is disposed of.
Under 2016, we paid them. Deeply obliged.
Yes.
Matter number 28.
It's pending at the hearing state. What is the IA in this case? There is some IA, no?
Same, connect.
28 is same.
Same.
Same. Connect kar dijiye.
Connect.
Connect the files of students
Yes.
with, है ना? It's already tagged.
Yes.
Yes.
Deeply obliged.
IA disposed of.
Yes.
Deeply.
Matter number 29 and 30.
In this matter, I am appearing on behalf of respondent numbers 2 and 3. I am led by senior counsel Mr. N.C. Dath. He is on legs in court number 12, Lordship. Matter may be passed over for the time being.
Timing would not be possible because we are having a different bench after lunch break. So we take a date. Saiwala,
My lord,
bench should be listed again.
any day, my lord.
Next week, Lordship.
As paid by council representing respondents. List for hearing on 9th May.
Obliged.
Yes.
Matter number 31.
My lord, I'm appearing on behalf of my senior, Mr. B. Chetri. I beg my pardon to state that due to some of his medical emergencies, he is unable to be present in the court. So
It is
may the-
stated that arguing counsel, Mr. Chetri, is not available for personal, on account of personal difficulty. List after
Lordship, may I pray for a date, your Lordship, the stay order is operating. Your Lordship.
waiting. Come up in May now, 9th May.
Obliged.
Matter number 32.
Yes. 32. None present for the parties, 6 weeks.
Matter number 33.
Yes.
May it please, my lords.
Yes.
My lord, the establishment under which the appellants were working falls under the control of the Assam Electricity Power Generation Corporation, my lord. The name of the standing council is not reflected in the cause list and therefore they are not present today.
Who is the standing council?
My lord, Mr. B.D. Das, senior counsel.
Look how
Therefore, may I pray, my lord, your lordship may direct that the cause list may reflect their name so that they may appear.
Tribunal matter, your Lordship, if possible, your Lordship, at an early date of hearing.
Early date now, no more dates in April, sir. Not possible.
The last part of April, your Lordship.
It is submitted by the bar that the standing counsel, Mr. B.D. Das, appears for the respondent. However, his name is not reflected. Therefore, the matter be listed on some other date. Mr. S. Portapur, learned counsel, appears for the appellant. Let the matter be listed in
25th April.
25th April.
Reflects the name of so.
Directed to reflect the names of all councils, including the standing council.
My lord, may I pray that it will be recorded as SCAPGCL, my lord. It would be more convenient.
Will record it as per the
I'm obliged.
information available.
Deeply obliged.
Matter number 34.
The matter will pass over for time being, madam.
The other side is also not there.
Not there, madam. Or it will come day after tomorrow, my lord.
Matter is adjourned as per it. Simple order sheet.
Hello.
Matter number 35.
Yes. Mr. KL.
Wait, please, your Lordship. Lordship, this appeal is directed against the order dated 25/9/2018. Lordship will find that at page 155.
Yes.
Here the petitioner before the single judge, he was unauthorizedly absent for 414 days. Thereafter, a proceeding was initiated against him. And he had challenged, he was dismissed from service pursuant to that proceeding. He came up in the writ petition, Lordship, and the learned single judge, Lordship, basing on the decision rendered by the Honorable Supreme Court in Krishnakant B. Parmar, that your Lordship will find it paragraph 14, the page is 158.
Yes.
Directed to reinstate him with 50% Lordship back wages. Now, Lordship, there is no quarrel with the proposition of law laid down by the Honorable Supreme Court. But one aspect of the matter which I would be urging before your Lordship is, after the proceedings were over, the employee filed an appeal before the competent authority. And when the appeal was being taken, what has happened was he had submitted some medical certificates. And the appellate authority made an inquiry as to the genuinity of the certificates. Now, if I may take your Lordship to page 143.
This is something which is not on record of writ petition.
It is that it is in our affidavit, Lordship.
Page number
143, Lordship.
Yes.
Here, and I take your Lordship to page 144. This is the report. With the undersigned verified the medical certificate of Dharmeshwar seal in reference to letter dated so and so. And as order by Superintendent SMK Civil Hospital so and so. And found the following facts. Attested copy of 2 prescriptions dated 25/1/13 and 2/6/13, which he filed before the proceedings, Lordship.
That's a reading.
Are
You're reading page number
144, Lordship.
verification of genuineness of medical certificate.
Yes, Lordship.
Yes.
If I may take your Lordship, attested copy of 2 prescriptions. It's the 4th line from above, Lordship.
Not enclosure is verification report and order for committee. These are the only 2 documents. And that is 146. You're reading. Yes.
Oh, I'm sorry, Lordship.
It's okay.
Attested copy of 2 prescriptions dated 25/1/13 and 2/6/13 are scrutinized and found that above name and number are not found in the hospital registration book. The medical certificate issued to Dharmeshwar seal on 30/12/2013 from SMK Civil Hospital, Nalbari, with stamp shows no issue number and hence not in office records. The spelling of the disease of the certificate is incorrect. The signatory of the certificate, Dr. S. Roy Borua, then SDM and HO of SMK Civil Hospital, Nalbari, has written in the certificate, presently retired. Considering the above, we are of the opinion that the certificates are not genuine. Now, Lordship, perhaps Lordship, this matter ought to have been looked into because he has.
Have you taken cognizance of this certificate and taken any action against the man
Now
on this ground?
Now he is out, Lordship. He
So
is not. no
these
longer in
documents, he filed an appeal. These
He
documents,
filed an appeal.
what is the
No,
observation?
This document he filed during the proceeding. Then when it went up in the appeal, Lordship, these documents, the genuinity of these documents were sought for.
What is the appellate authority say about it?
In the, I take your Lordship to the appellate authority's order that your Lordship will find.
Para D 152. See, the verification was done 3 years later.
Yes, Lordship.
Government
That is-
hospitals, you don't find records.
but
Lordship, perhaps Lordship, but since there is a finding that the uh, documents were not authentic, Lordship, and he had taken a clue from those documents, Lordship. Otherwise, Lordship, law is well settled, Lordship, that overstay Lordship of leave cannot entail Lordship.
Dismissal. Too harsh, too harsh.
But perhaps Lordship, this matter, this aspect of the matter ought to have been considered, Lordship, since it was on record. Because he.
See, the doctor retired. Maybe the doctor might not have entered it in the records of the hospital. There's no allegation that the signatures are forced.
But Lordship, it says those documents were not genuine and it is not in the records.
Verification is done after 3 years.
That Lordship, I cannot deny.
Maybe that might negligence thrives in government hospitals. Maybe it's too harsh.
That
My lord, to reply to the affidavit in opposition, we filed one affidavit in reply, my lord. That reply, my lord, that has not been enclosed. But in the reply, we have stated, my lord, the doctor, my lord, already retired and he certified. My lord, later on, after that, my lord, we approached the doctor, my lord, this is the problem, and doctor, my lord, certified that yes, this is issued by me. So therefore, genuineness of the document is not in doubt in view of the, my lord, subsequent, my lord, certificate issued by the doctor 24/2018, my lord. He already retired. So therefore, the office may not have that, my lord, but the certificate is genuine. And my lord, moreover, that the order, my lord, 1/3/2019, lordship, in this appeal, my lord, there is an order. While staying the, my lord, order, my lord, last para, in the meantime, there shall be an interim stay insofar as the grant of 50% bequest, subject to the appellant reinstating this service, the respondent into service within 3 weeks from this day.
Okay,
My lord,
so-
he has been reinstated, my lord. Now, my lord, in my understanding, my lord, this appeal is limited to
Back wages.
50% bequest.
So what do you say about that?
My lord, so far that is concerned, my lord, there is a judgment. My lord, here it is categorically stated that while reinstating in service, my lord, in parallel, Sarma, 1989, SCC 448, my lord, short one paragraph only I will be referring, my lord.
Yes.
Here, my lord, directly come to para 22, my lord. Last page, my lord, para 22, my lord. When the termination order is set aside by the court, normally the servant becomes entitled to bequest and the consequential benefit. This case had take history from 1976 onwards.
It's just bitter. It's not ratio descendi.
My lord, now thing is that, my lord, here is not a case that I have been granted 100%. My lord, in the labor case court, what happened, my lord? While reinstating 100% bequest allowed. But in a writ case, my lord.
Nowadays, labor courts awards are altered by saying no reinstatement. This lump sum compensation, hundreds of judgments.
My lord, now,
So-
my lord, the judgment referred by the learned single judge, my lord.
Any judgment which can justify this direction of 50%.
Yes, my lord, that Kusan B. Parmar, which has been relied upon by the learned single judge, 2012, CSSC, my lord. Yes, my lord.
Pass it on.
My lord, in the referred judgment also, my lord. This is the
Chaudhary,
case.
your appeal is admitted only for 50%. Read the order.
I have gone through Lordship.
Then,
I have gone through Lordship.
because it says, since the consideration of the matter is required with regard to other aspects.
My lord, here also unauthorized absence, my lord, that unauthorized absence to be proved, my lord, as willful. Para 17, 18 and 19. And thereafter, my lord, that so far 50% is concerned. These judgments also concluded, page paragraph 25, my lord.
Yes.
Reinstatement granting 50% bequest, my lord. This is the judgment referred by the. learned single.
Any judgment on this aspect? Back wages.
50%.
Lordship,
This is the only argument left with you, sir.
yes, Lordship.
Then
Lordship, since he was out of service for the,
that's what we are asking you.
and
There are judgments to the contrary.
yes, Lordship.
Yes, lordship doesn't make the case for you. You have to be there with the judgments.
Lordship, I was on the termination, Lordship, I was.
Termination,
I
you can't
present.
argue. Your appeal is admitted only on the other aspects.
Yes, Lordship, because farmer's judgment, Lordship, if the documents are not
No.
genuine, Lordship, I was trying to make a point on that.
That argument is not available, sir. If you want to cite any judgment on the aspect of 50% back wages, we'll permit you, we'll close the order. Judgment, reserve the judgment,
I can furnish it. by
furnish the
tomorrow, Lordship.
judgments. Okay. Arguments have been heard. Judgments.
Deeply obliged. Obliged.
Item number 36.
Yes.
May I please, your lordship?
Yes.
My humble submission is that, my lord, this is a matrimonial appeal, my lord, filed by the wife, my lord. My lord, fact remains that, my lord, in the year 2018, my lord, I mean, lordship taking the brief of the fact, my lord, two separate cases, my lord, divorce suit
The other
were
side.
filed in two different districts, my lord.
Where's the other side?
One
Where
in
is the
the home
respondent?
place of wife.
Who's for the respondent? Who's for the respondent?
If my lord. Yes, thus.
Respondent did not appear. Your client did not appear there in the family court. So it was an ex parte decree virtually.
Yes, my lord.
So you should have filed 913. Why appeal?
My lord, what happened in this case, my lord?
Yes.
As per section 21A of Hindu Marriage Act, my lord.
Yes.
It says that, my lord, if two separate suits are filed in two different districts, my lord, by one by husband and one by wife, my lord, then both to be heard together in that district where the earlier petition is filed, my lord.
So was there
this
any
case, my lord,
application?
in this case, my lord,
Was there any application to club the cases?
my lord, what happens actually, my lord?
Yes.
The husband filed in Kachar district, my lord.
Yes.
Wife resides in Hailakandi district, my lord.
Oh.
So both suits were well continuing, my lord. I received summons in Silchar case, my lord.
Yes.
But at that time, my lord, my case was also pending in Hailakandi, my lord.
Yes.
And husband appeared and filed WS also. I was of the impression that, my lord, definitely husband would inform the court at Silchar about the pendency of this case, my lord.
Why should the husband do that?
My lord, because the law provides that both to be heard together, my lord. So in that way, my lord, I did not participate, my lord.
Would non-hearing of the two suits together vitiate this order?
Now, my lord, my suit is still pending, my lord.
Maybe.
I have one
maybe,
daughter also, my lord. But in the imprint order, my lord, no maintenance award has been given to my daughter also, my lord. And
Sir,
my
you
lord,
never moved any application. Is it to be done by the court suo moto? Is it required to be done suo moto? The appropriate remedy was to file 913. Setting aside of the ex parte decree. Given your client wrong advice, Mr. Counsel. Contested. By now, he must have remarried. That is for sure. Desertion. Oh, he also filed restitution of conjugal rights. That was also decreed.
Yes.
You did not go. Then what else is the option? Dismiss. Yes.
Letter numbers 37 and 38.
Please, Your Lordship. Both the appeals arises out of the judgment in order dated 1/9/2016. Initially, all the appellants together filed a writ petition. Thereafter, in the writ appeal, they have divided, and that is how there are two appeals here. There was a claim for release of their salary since they were working since the year 1998 after being appointed under the Operation Blackboard scheme. And during the writ proceedings, their current salaries were released in the year 2013, but the department denied releasing of their area salary on the ground that their appointments were not illegal. That is the whole case. They were relying on a judgment of the earlier judgment passed in an earlier writ petition filed by the present appellants that their appointments were their regularizations were after the schools were provincialized. That is why they're not entitled to salary. But
That's what the law is.
Yes, but that judgment was passed in an incorrect set of facts. In fact, what
Are you aware of Supreme Court judgment by the name of Jagdish Narayan Chaturvedi? Precisely on the same set of facts. Date of regularization, no benefits before that.
Lordship, in this case, the department themselves say that they have been appointed and have continued in service as per the rules.
Appointed against and cadred post way back in 1999. Let us read your pleadings. Operation Blackboard was not covered under the service rules, we presume, right? How could the appointments be against and cadred posts?
No, they were regularized against those sanctions. If your Lordship kindly peruse.
Regularization, let us see the regularization order.
Yes,
Then. Yes.
Page 39.
39.
39.
Yes.
This is of the appellant number 1. The first appeal, I'm taking up the writ appeal number 57 of 2009.
Yes. 39.
39 is the regulation of the appellant number 1. In pursuance of post-sanction order of the wide letter number so-and-so, the service of so-and-so and so have regularized against the sanction post, sanction 2 post against so-and-so in the scale of pay, plus other allowances as admissible under the rules with effect from. Yes. And subsequent, the other regulation orders of the other petitioners and appellants we have enclosed.
Yes.
Thereafter, what they did was that they withdrew
this order.
After that, they canceled the regulation order and thereafter again withdrew the orders of cancellation of regularization. The withdrawal orders at page 52, the Lordship peruses page 52. The cancellation order was withdrawn.
Page number?
Page 52.
Yes.
Regularized, cancelled, then thereafter they withdrew the cancellation. In pursuance of government letter dated so-and-so, and Director of Elementary Education, Assam's letter number so-and-so, the cancellation order of this office letter number so-and-so dated 25/11/1999 is hereby withdrawn from the date of cancellation.
Right.
They withdrew the cancellation order and as such, the appellants were continuing in service without any salary. Thereafter, they filed a writ petition for claiming salary. And that writ petition was, and during that pendency of that writ petition, they were again regularized in the year 2013, and they were released the current salary. If your lordship peruses the affidavit, additional affidavit which the commissioner had filed at page 125. In the proceedings, the commissioner had filed the affidavit. The relevant paragraph, if I may point out, paragraph 5 at page 126. May I read out paragraph 5? It states that honorable.
Can we read the judgment dated 21/7/2004 first?
Yes.
Which you have annexed at page 62.
Yes.
Were the petitioners appellants part of that writ petition?
Yes, the appellants were part of the writ
Read
petition.
this judgment, please.
And Lordship, if I may just point out one aspect here, the other writ petitioners who were along with them in that writ petitioner, they have all been granted the relief of salary, current as well as arrear. They were also regularized.
From which
again
date?
From the date of initial regulation in the year 1998. Those orders are also.
We'll see. First read this order.
Yes. 22 petitioners have joined in the present writ application to call into question an order dated 27 September 1999, issued by the Secretary to the Government of Assam Education Department, requiring the Director of Elementary Education Assam to cancel the regularization of 52 numbers of ME school teachers in Nagaon district, which includes the 22 petitioners before this court. The fact lying in a short campus and only what is essential is being stated. The petitioners were appointed by the managing committee of different ME schools on the basis of the resolutions taken after the aforesaid ME schools were provincialized. These happened on different dates before the year 1991 to 97. Thereafter, the petitioners claim to have continued in service until by a series of identical orders passed on different dates in the year 1999, the service of the petitioners were regularized. The government subsequently took the view that the initial appointment of the petitioners made by the managing committee of the schools after provincialization being illegal, no right of regularization can be recognized in the writ petitioners. On the aforesaid basis, the impugned directions contained in the order dated 27 September 1999 were issued. Aggrieved, the present writ application has been filed. This court in its judgment and order dated 29 September 2003, passed in WPC 2560 of 2001 and other connected cases on an elaborate consideration of relevant portions of the Assam Secondary Middle English Schools and High Schools Provincialization Rules 1979 has taken the view that the managing committee of the provincialized schools are not competent in law to make any appointment of teachers. On the aforesaid basis, the claim for regularization on the basis of long years of service rendered as raised by the petitioners in the aforesaid bunch of cases was answered against the petitioners by holding that no such right of regularization can be recognized in law. In answering aforesaid question, this court in its judgment and order dated 29/9/2003 had also taken into account the pleas advanced.
Can we have a look at that judgment? This judgment which is referred to 29 September.
Yes, that is not so far as that aspect of law that is settled. I'm not disputing that, questioning that aspect of law, that that after provincializations, no appointment can be made by the managing committee of the concerned schools.
Okay, so regularization has been held to be illegal by this court in the writ petition, or rather the action of non-regularization has been affirmed with disposal of the writ petition.
No,
Disposal of the writ petition, yes.
The actual set of affairs that was not placed during the what has happened was, as I had pointed, submitted before.
The order of cancellation was withdrawn.
Was withdrawn.
This fact was not brought to the notice of the court.
This fact was not brought to the notice of the honorable court.
Then,
and this resulted in dismissal of the.
Whereby the decision to cancel your regularization has been affirmed.
But the regulation orders were cancelled and they were continuing in service.
Very well.
And the
Carry on, all right.
And the other petitioners who were there along with us, they have been granted the full relief.
They have again been
This you
regularized.
are asking for negative equity.
No,
That's
not
not
negative.
possible.
Lordship, I'm relying on the statement. I'm relying on the statement by the commissioner, by the department, as I was pointing out at page 125, the affidavit which was filed. They themselves say that we were appointed and continued in the schools as per the rules. If your lordship takes up the affidavit which was filed at page 125 by the commissioner. Paragraph 5, 126. The deponent states that the Honorable Court by the order dated 21/7/2004 passed in WPC number 6249 of 1999. It was held that the petitioners were initially appointed by the managing committee after provincialization and their services were regularized in the year 1999, which was contrary to law as held by this court in its judgment and order dated 29/9/2003. The Honorable Court further held that the initial appointment of the petitioners being illegal, no regularization of such illegal appointments could have been made, and therefore the Honorable Court was pleased to dismiss the writ petition. Thereafter, they preferred a writ appeal number so and so challenging the judgment and order dated so and so, which was subsequently withdrawn. Therefore, the finding of this court has already attained its finality. The service of the petitioners ought to have been dismissed as per the Honorable Court's order. However, they were clubbed together in the group of 52 teachers whose regulation orders were cancelled and subsequently cancellation orders were withdrawn in the year 2002. The government has regularized the service of some of the teachers whose names are reflected in the group of 52 teachers, provided they are serving in their school as per rules. The service of the petitioners were regularized with effect from 5/10/2013 with prospective effect, and therefore they are not entitled for area salary for the period from 1998 till the date of regularization. Now, next paragraph, service of the petitioners were regularized as assistant teachers against vacant posts in upper primary schools with effect from 5/10/2013. Lordship, the regularization orders of 1998, they themselves had cancelled it, then thereafter have withdrawn. So the
Page
those
99. Page 99. Yet another order by this court, wherein there is no reference to the withdrawal of this cancellation. Read.
Page 99, Lordship.
Yes. Order dated 1/12/2008.
Lordship, this does not pertain to these present appellants. This is this writ petition, this order. The appellants are not covered by this order.
There are 25 people in that writ petition.
No, this is a different order. They are not, even they will acknowledge it. This is, we are not covered by this. We are not. The facts which I have submitted, they will also not dispute as it is reflected in the affidavit filed by them. They are only relying on the 2004 judgment wherein it was not pointed out that the department had themselves withdrawn the cancellation orders and have allowed us to continue in service. And thereafter, they have also clubbed those 52 group of 52 teachers whose initial regulation orders were cancelled and thereafter withdrawn. And thereafter, they have been granted the full benefits from the date of initial regularization. And it is not disputed that they are working since 1998. Since we are rendering service and
What about this order at page number 104? Are the petitioners part of that order?
104?
Oh, yes. Must be.
Yes. Lordship, these are the persons who were petitioners with us in that petition which was dismissed. They have been again regularized in the year 2010. Thereafter, they were granted the benefits from the year 1998 itself.
From where do you get this?
Lordship, there is a order at 109, page 109. They had also preferred a writ petition, page 109. Order, date of order 18/11/2011.
All right, read the SB order now in your case.
Lordship.
Read the single bench order.
Yes.
Yes. Page
16, it starts at page 16.
Yes.
19/2000. Since the subject matter of so in WPC number 2698 of 2010 and 1005 2012 are somewhat interrelated. They were hard
Page
together.
number?
Lordship, page number 16, 16.
16.
There were two repetitions which were
Yes,
discussed.
all right.
I'll start from the operative portion
Yes,
from page 17. 52 numbers of post, paragraph 5 of the repetition judgment. 52 numbers of posts belonging to the Operation Blackboard 4040 group of teachers in the district of Nagaon were cancelled by the government of Assam in the education department on 27/9/1999. These 52 posts included the post held by the petitioners. All the 52 numbers of teachers forming separate groups challenged the legality and validity of the aforesaid order dated 27/9/1999 before this court by filing several writ petitions. Writ petitions filed by petitioners along with others was numbered as WPC number 6246 of 1999. An interim order was passed in the said writ petition directing the respondents not to give effect to the cancellation order. Following such interim order, cancellation orders in respect of the
cancellations were withdrawn because of the interim order,
interim order.
not on the own doing of the government. Yes,
It is stated that notwithstanding withdrawal of cancellation order and continuation of the petitioners in service, salary was not paid to the petitioners, though several proposals were submitted by the district authorities for payment of salary. The writ petition filed by the petitioners and others, that is WPC number 6246 of 1999, came up for final hearing on 21/7/2004. By the judgment and order dated 21/7/2004, the writ petition was dismissed after holding that initial appointments of the petitioners being illegal, no regularization of such illegal appointments could have been made. It is stated that when this court passed the judgment and order dated 21/7/2004, withdrawal of cancellation order was not brought to the notice of the court. Petitioners preferred writ appeal number so and so before division bench, questioning the correctness of the judgment and order dated 21/7/2004 passed by the single bench. An interim order was passed on 24/8/2005 to the effect that if the appellants were petitioners were in service, they should be allowed to continue until further orders. It is stated that since then the petitioners have been continuing their service, but no salary has been paid to them. Representation submitted by the petitioners.
maybe just ask you, where is the judgment of writ appeal number 292/2005?
The withdrawal order.
You have withdrawn that appeal.
The Lordship, the dispute, the impugn order was the cancellation of regularization, and that was withdrawn by them. And they were continuing.
That was contingent upon passing of the interim order of this court. That interim order was decided, the order of cancellation was gone. Withdrawal was gone. You withdrew the appeal, that gives finality to the single bench judgment wherein it is said your services could not have been terminated.
The government took a decision that these cancellations were wrong. And that is why pursuant to a government decision.
Carry on with the judgment. We'll see.
It is stated that since then petitioners have been continuing their service, but no salary has been paid to them. Representations submitted by the petitioners did not receive any consideration. It is stated that a group of 14 similarly situated teachers, like the petitioners who had together filed WPC number so and so, had filed a writ petition seeking a direction to the respondents for release of salary. The writ petition was registered as WPC number 4932 of 2009, wherein directions were issued by the court for personal appearance of the higher authority, who on appearance had given assurance to the court that salary of these petitioners would be released. In the above factual backdrop, present writ petition has been filed seeking a direction to the respondents to release the salary due to the petitioners. Respondent number 2 in his affidavit has stated that petitioners were appointed by the managing committee of the respective schools after the schools were provincialized. Subsequent regularization of service of the petitioners were held to be illegal by the government on the ground that initial appointment of the petitioners were made by managing committee.
The order dated 5/10/13. Is it challenged anywhere?
No.
Read that order. That would conclude the things. Where is that order?
114,
145,
114.
yes.
We have the government of Assam is pleased to adjust, regularize the services of 13 assistant teachers of upper primary schools under Nagaon district against similar number of sanctioned vacant posts in the scale of so-and-so, plus other allowances is admissible under the rules from time to time. The Honorable High Court in COPC number so-and-so, rising against the order dated so-and-so passed in and other similar cases with immediate effect. These teachers were originally appointed against the allotted post under OBB 4040 scheme created by government letter number so-and-so dated 24/4/1998.
Created by.
Yes.
The names of teachers and name of schools were working were posted. The names of the present appellants are reflected at serial number 3, 4, 6, 9, and 12. And the other persons who were also regularized by the same order, they also form that group of 52 teachers, and they have been granted the full benefits from the year 1998 since the date of the initial regularization.
Madam, this order clearly says against regularization with effect from 5th October 13. That order is not challenged anywhere. How can you claim benefits of an earlier date? Let us know.
Lordship, there is one more aspect. They have the fact that it is not in dispute that they were working since the year 1998.
Maybe
And
the court, when your earlier writ petition was dismissed, against which you filed an appeal, there's a positive finding that your services could not have been regularized. You were never regularly appointed. Now the government has regularized your services with effect from 5th October 13. You can't claim anything. That order is not challenged. It's certain.
no,
5th October 13.
Lordship, these we have not because Lordship
Date of regularization, 5th October 13. You are not aggrieved of that.
Yes, but the fact remains that we have been working since.
Irrespective. So you should have challenged this order saying that our regularization should be retrospective. Have you challenged that?
Those regulation orders of the year 1998, that remains.
Then
Because
there is a need for a fresh regularization.
Yes, that also, of course, we have question.
Read your
there is-
pleadings that there was no need for a fresh regularization. Read.
Yes, that we have, of course, during the pendency of the read proceedings, that regulation order came.
So
Uh,
is there any affidavit saying that this, we propose to challenge this part of the order which says regularization with effect from 5th October
There
13?
is no separate challenge that, of course, that is admitted. There is no
This
separate-
order is final.
But during the,
Very well, very well. Carry on with the judgment.
Lordship, there is one more order which reflects that the government had themselves taken a decision that with regard to these 52 teachers, they will be entitled to their benefits from the year 1998 because it affidavit.
Yes.
We had filed a rejoinder affidavit at page 129
Yes.
during the read proceedings 129.
129.
129.
Yes. Read please.
Third paragraph, continuation of the third paragraph at page 130. The subparagraph of the paragraph 3. For the department has taken a decision to treat the case of the 52 teachers on the same footing as is reflected in the order number so dated 21/5/2011 passed by the Commissioner and Secretary to the Government of Assam. In case of one Mojibur Rahman, it has been decided that he does not belong to the 52 teachers. His claim for regularization and release of arrears salary is not justified. However, the Commissioner and Secretary decided that as the petitioner has been working without any salary for quite a long period, his arrears salary was released by creating a supernumerary post. Lordship will kindly peruse this order 21/5/2011 that we have enclosed at page 132.
Different set of petitioners.
No, Lordship, this refers.
This
to
is,
us.
okay,
No,
yes,
Because we are the group of the 52 teachers.
yes, read.
The order dated to 28, 2009 of the Honorable High Court passed in WPC number so and so. The report of the Director of Elementary Education Assam wide number so and so dated 5/10/2010 findings. The petitioner was appointed by the Managing Committee of so and so school on 10/3/94. Therefore, the school was provincialized with effect from 1911-1991. The petitioner was regularized by District Elementary Education Officer Nagaon by this memo number so and so in pursuance of government letter number so and so dated 9/12/98 against OBB scheme with effect from 24/4/98. The
Yes.
District Elementary Education Officer has cancelled the allotment of 52 posts in pursuance of government letter by number so and so dated 28/9/1999. However, the cancellation order was withdrawn as per government letter number so and so dated 25/11/2002 in compliance of Honorable High Court's direction dated 8/12/1999 and so and so, so and so. The present writ petitioner has made a claim to treat his case on the same line with that of the 52 teachers whose regulation order was cancelled, and later on, the cancellation order was withdrawn as per government order number so and so dated 25/11/2002, pursuant to the Honorable High Court's direction. In the writ petition, the petitioner does not seem to have clearly stated if was within the group of 52 teachers, some of whom approached the Honorable High Court by WPC number so and so, and other similar matter. On verification of the list of 52 teachers, the name of the petitioner is not found there. After careful consideration and examination of the reports and records, it appears that the case of the petitioner does not stand on the same footing as that of so and so in WPC number 2741 of 2008. Therefore, the claim for regularization and release of salary does not seem to be justifiable. Lordship, in case of this is a different person, and just because he, after verification, he was not found to be in that group of 52, his claim for benefits was rejected.
Right.
But considering the fact that he was working since the date of his regulation, he was released the salary, etc., by creating a supernumerary post. Now, and the government has themselves withdrawn the cancellation order, and thereafter also they have come to a finding that these group of 52 teachers are to be treated alike. And so if the other, after themselves taking a decision that they are to be treated alike, so we being given a different treatment is discriminatory. And there is one more, Lordship, there is one more judgment in respect of this group.
Yes.
The Honorable High Court directed that these group of 52 teachers, they had a group of amongst the 52 had approached the Honorable High Court for release of their salary, and the Honorable High Court had, after perusing at the entire materials on record, was of the opinion that they are entitled to salary because the cancellation orders were with the cancellation of regulation having been withdrawn, and there is no dispute with regard to that fact. They have been working since that date, so they are entitled to salary.
Read page para 23, 24 and 25 of the imperial order.
142.
23, 24 and 25 at page 22. That would make things clear. Yes.
Lordship, this is with regard to that order was not enclosed. If your Lordship calls for the record of the writ petition,
This is
everything
not
was
saying that the
enclosed,
order was
everything
not enclosed. Court says that order is not challenged. So we have no reason, no occasion to comment on the veracity thereof. The order from which you are trying to draw equality. Read, please.
Yes.
Para 23.
20.
Yes.
Since beneficiaries of these two orders, namely 36 assistant teachers, are not before the court, and since orders sanctioning payment of arrear salary to them have not been questioned, court would not enter into this aspect of the matter, save and except to place on record that because of failure of the education department, its officials and their counsel to place before the court the judgment and order dated 21/7/2004 passed in WPC number so and so, contradictory orders were passed subsequently.
Yes.
On the submission of learned counsel for the petitioner that there is violation of Article 14 of the Constitution of India, it goes without saying that equality visualized in Article 14 is a positive concept. It cannot be applied in a negative manner to perpetuate illegality. In fact, petitioners are, if it can be said, so lucky that the services have been regularized with effect from 5/10/2013, despite a clear order of this court holding the initial appointment and regulation to be illegal.
Now please come to the case of the other petitioner. And particularly para 28 and 29, what we observed regarding the order not being challenged.
Lordship, this order is not under challenge here. This with WPC 10, in fact, this has taken a different, there are other, that was challenged and again it was remanded back to the Supreme Court with regard to, and this petition is not similarly situated as the present
In
appellants.
any event, the order dated 5/10/2013
Yes.
not being challenged. A simple query now, answer that. Whether you can indeed claim that you should be given benefits from an earlier date. Answer that query.
Lordship, yes, of course, technically.
Technically, no,
yes,
legally.
But yes,
Legally,
but
that's an order with the state passes, regularization from the state. And that is absolutely justified. They could not have even done it because their original appointment was not against a substantive post. It was not a regular appointment. Uma Devi.
No, again, if we go back to, if we go to para 54, Huma Devi, they were continuing in service without any order of the court.
So here also, they continued in service. The cancellation was because of an interim order, which was later on merged in the dismissal order of the petition. So there was no cancellation of the regularization cancellation order. The cancellation of appointment has been affirmed by the Red Court and your appeal has been withdrawn. So nothing left at all, madam. Thank you.
Lordship, for once, just the judgment dated 31/3/2009, the last.
Yes.
There are findings. At page 142.
Yes.
Lordship, the reason also why we did not challenge that order of.
Yes.
The order of regulation dated 5/10/2013.
Yes.
That was not put to challenge because we were under the expectation that the other persons who were also regularized along with us, they were given the full benefits. So the government.
By effect of order passed in relation to another employee, you would get the same benefits even though a pertinent specific order is passed by your clients who are litigating since decades. They are not aware of the consequences. What are you talking, madam? All right, read whatever you want to read.
Lordship, the third paragraph
Of
onwards, page 142. This is a judgment and order dated 31/3/2009 passed in WPC 2741.
in whose case?
Lordship, these are the petitioners who were also similarly situated.
Similarly situated argument doesn't lie, sorry.
Lordship,
You're not
they-
entertaining that
They
argument.
form that part of that group of 52 who.
Maybe.
Lordship, the fact remains that they have been working since.
In this order, whether this earlier order of the single bench, whether this was brought to notice of the court or not.
Which-
2004.
This was brought to the notice of the.
Read,
Honorable Court.
please. Read.
Lordship, in respect of these petitioner, that order is not covered by with respect of these petitioners, that 2004 order. But Lordship, from paragraph 3, in short, the petitioner's pleaded case is that on being initially appointed by the managing committee of the respective institutions, they joined their posts and were eventually regularized therein with effect from 24/4/1998.
The single bench observes that the order dated order of 2004 was not brought to the notice of the court. That is why these inconsistent stands and the orders whereby different views are taken. That is the reason.
Lordship, calls for the record of that, everything was there. In fact, considering the fact that even if they were illegally appointed, all the in that writ petition.
You were the counsel in both the cases.
Yes, even the
You
school.
could have brought it to the notice of the court.
Lordship, everything, we brought it to the notice, everything was enclosed there, nothing was suppressed. In fact, Lordship, considering the fact that that judgment was there, the single judge had directed us to implement the managing committees of the school because we were appointed by the managing committees of the school.
Very well.
And considering the fact that we were working, we were rendering service. On that issue, Lordship, taking on that ground, we were, the direction was issued to release our salary. We were working.
Very well.
If the government had taken our services.
Very
that
well,
is
Ji.
an
Okay, thank you. That should be enough. Yes.
Already taken note of that the judgment of 21/7/2004 has attained finality. And there is a declaration specific that their appointments were illegal.
Yes.
And in fact, my lord, the default on the part of the departmental authorities and the standing council, then, my lord, paragraph 2, the honorable single judge has taken note of. That
Please
these were
read out the page,
Page-
from page number.
page 21,
No, no, the 2004 order.
my lord, 2004 order, page 62.
62.
The findings at page 64, my lord, para 3,
Yes.
categorical finding. The petitioners in the instant case were admittedly appointed by the managing committees of the school in question after provision, whereafter they were regularized in the year 1999. Such regularization have been held to be contrary to law by this court in a judgment order dated 29/9/2003 as discussed above. The initial appointment of the petitioner being illegal, no regulation of such illegal order appointment could have been made. Thereafter, following the law laid down by the honorable court in a judgment dated so and so in WPC number 25060 of 2001 and other connection, no infirmity can be attributed to the impugn action of the state government in
Yes.
directing the director elementary to recall, cancel the regulation made. So, my lord, the finding,
Where is the order of the appellate court? Rate appeal?
read appeal, my lord, the order they have not enclosed. They preferred an appeal that was withdrawn. So this order has attained finality.
That is appeal number 292.
Yes, appeal number 2.
They have annexed the interim order,
Yes.
but
And by virtue of that interim order, they continued again. So the continuation, despite they were illegal, but there was a lenient view taken by the government in the regulation.
that's true. Dismissed.
Can I just place one judgment with regard to
Please do.
judgment of the division bench of our High Court,
Let's see.
2000, reported in 2007, 1 GLP 4090.
Yes.
Here also there were illegal appointees, but direction was given to release the salary as because the government had utilized the services of the petitioners.
Whether
Lordship,
Uma
just
Devi is
one
considered
paragraph.
in that judgment?
Lordship, just one paragraph. I mean,
Uma Devi is considered or not?
this is after post Umadevi, 2007, 1 GLP 409.
ML Kesari,
Uh,
sanctioned post. 5/10/13 says posts are created to regularize them. So obviously they were not working against sanctioned posts.
The earlier regulation order that still stands.
Oh, that you argued.
Lordship.
Thank you. Very well.
In fact, my lord, on that one, there is a judgment of the Honorable Supreme Court, my lord,
Please.
saying that if the appointments are illegal, my lord, they are not entitled for anything, including salary.
Please give it.
Page para 36. The second
Para 36.
para 36. No monetary claim of right of monetary claim can arise.
Yes. Dismissed.
High level.
Item number 39.
My lords, having faith, it would release happily within time. I know there are difficulty. I talked to Mr. Barpujari. He is not well. But we are defending a judgment My lord, of 22/9/2014, I am a retired person. So almost a decade.
Continue to have
If
faith.
your lordship permits me, I will do my part.
Can't be done in
They-
piecemeal,
they-
sir. Can't be done in piecemeal.
Yes, sir.
So
When is he available?
Lordship is down with pharyngitis suddenly yesterday, Lordship.
So
Very, very sudden, your Lordship.
No, that's all right, but when is he likely to get back? That's what we want to know.
After 3-4 days, your Lordship, because
that will go in end of April.
then in case, my lord, on fifth.
25th.
On a hearing day only.
25th.
25th.
Yes.
25th of April.
Calendar is here for your convenience, a big one.
My lord, I have given the affidavit in reply, then written argument also.
Why do you want to argue twice over?
Yes.
Then
And
government council, Mr. So-and-so is reportedly unwell. List on 25th April for hearing.
I'm deeply obliged.
Matter number 41.
lordship.
May I please, your lordship? Lordship, in this present appeal, the petitioner has challenged the judgment and order dated 28/2018 that was passed by the learned single judge, lordship. In this writ appeal, what happened, lordship, when the notice has been served upon the respondent number 1, thereafter he personally appeared before this honorable court and subsequently he filed a affidavit. That affidavit is on the record, lordship.
Yes.
In the affidavit, he stated that, lordship, he never filed any petition before this honorable court assailing the appointment of the present appellant, lordship.
Then you go for an FIR. You seem to have won over the red petitioner. So it seems.
So the page number 37, lordship. And and honorable court has directed the registry for inquiry into the matter.
What is the inquiry report? Is it there?
Yes, lordship.
We'll have to call for the inquiry report.
I have not received, lordship.
Hmm?
I have not yet been furnished, lordship. Inquiry report, lordship.
Where's the direction? They stay in your favor. When is the order of, what is the date of the order? Thereby inquiry was directed. You're not sure of it.
Lordship, I have to go.
All
to
right.
the record.
None present for the respondent. List up 4 weeks.
Hello.
Item number 42 and 43.
Whenever there is a question leak up, it always creates problem, my lord. This is-
You can very well presume that I am unaware of that.
My lord. Actually, in this case, the judgment stated, my lord, 20th of May 2020.
Probably
That's
we will
a
not
page
be able to
159.
complete it today because we have a different bench.
Bench
for lunch.
my lord.
So you can, maybe we can have it in the first week of May.
My
We already
yes,
kept many orders for dictation.
my lord.
So we'll re-notify the remaining matters in May. Okay. You can give convenient dates to the council.
I have prepared written arguments. May I place it on record, my lord? So
On
that kind of
the
can
date
also-
when they are taken up.
Fine.
Please retain them with yourself. We'll consider it on that day.
My lord.
We can maybe have it on 9th May. 9th May.
Obliged, my lord.
And the remaining matters also, Mr. KL, you can tell him.
This is good.
KL,
49 also, my lord, that is land acquisition matter, my lord. Land has been acquired in violation of the.
you can take a date in May. Whatever dates suits you.
Despite that report, my lord, everything was done in a, so would like to bring it on record. Only 1 day's time I require, my lord. Can I suggest this?
I
Can I?
cannot say no to that.
Naturally, if that is so, that would be a serious
Yes,
thing to be considered.
yes.
All right.
All that I was trying to submit is, my lord, we'll file our affidavit by tomorrow. If my learned friend wants to file it, let it file the day after tomorrow. Friday, lordships can take up the matter if it is not otherwise inconvenient.
And again, disturbing the board on a admission day would not be
Or maybe on next Tuesday, my lord.
Tuesday. Tuesday will have.
Next.
Yes. Mr. Kench of the senior advocate, hearing for the appellants, submitted, appellants in so and so, submitted that he has come up, he has been provided document which might have a material bearing on outcome of these appeals. He submits that he may be allowed to bring the document on record to an additional affidavit, which would be filed by tomorrow. Mr. Saikia, AG Mr. Saikia does not object to the said submission. In this background, the additional affidavit along with the document be placed on record by tomorrow. The learned advocate general would be at liberty to file a counter affidavit.
Will be at liberty, but we do not because ultimately.
At liberty, at liberty.
Yes.
If so required, list the appeals for further hearing on
Tuesday, my lord.
25th. At
20th, I have some difficulty.
25th.
20, just 1 second.
You want it?
25th, I think it is a.
Oh, sorry,
Saturday.
25th is Saturday. 28th.
29th, lordship.
29th
Yeah.
at
2 p.m., my lord.
not at 2 p.m. then. We'll take it up at 2.
Anytime. my lord.
3:30.
No,
3:30 p.m. Yes, because most of the arguments have been completed.
Yes, yes. My lord, instead of tomorrow, lordship, can you make it day after tomorrow? I'm told, my lord, that he's.
Day after tomorrow.
Day after. We'll file by day after.
Day after.
Deep clear.
Highly obliged, lordship.
Item number 4.
Yes.
Wait, please, lordship.
Yes, judgments. Have it. This one I said, this one more important. 2010.
I'm grateful to your lordship for accommodating on the last occasion. I apologize for not being present on the last occasion.
No issues, no issues. Just hold on. We had put you a query regarding non-recording of evidence, right?
Yes, your lordship.
Now you look at this judgment. Pass it on. These two judgments. This one also. Now do you answer the propositions laid down in these two judgments? Yes. Proof by leading evidence. Even in an ex parte inquiry, evidence has to be led. In your regulations,
Yes.
regulation 13 says oral evidence. Where is the oral evidence?
Now, oral evidence, it may be led. It may be led. It is
Shall be. That is what Saroj Kumar Sinha says.
now
Otherwise, how do you prove the charges?
what I propose before your lordship is that I will quickly address your lordship on article of charge number 3.3.
Yes, go ahead.
Basically, I'll
Go ahead.
summarize the argument. As far
Yes.
as these two judgments are concerned, I would like to quickly respond
Yes.
to the judgments. In
Yes.
this particular judgment, 2010 4
Saroj Kumar Sinha.
yes,
Yes.
this is life insurance, LIC versus Rampal Singh.
Yes.
In this particular judgment, the facts of the case are like that. The documents which were relied upon by the inquiry officer or the authority concerned, they were not produced themselves. They were not
Produced
produced and
in
they were
what
not
manner?
also marked. They were not also marked.
So, did you mark it, the documents?
Yes, ME 70.
In whose evidence?
No, not by way of evidence. That is what
They can't be marked like that.
that is what I'm proposing.
Yes.
Proposing to satisfy your lordship
Yes,
upon,
yes.
based on the judgments which are of the honorable officer.
Okay. Saroj Kumar Sinha. Next judgment. The other judgment read. Oral evidence. Yes. Read at note D. That would make
In
things
this
clear.
case, the documents themselves are not supplied to the delinquent officer.
Question here is how documents are to be proved. It was an expert inquiry.
Yes.
So there's no question of supplying documents. Irrespective thereof, how do you prove the documents?
My basic submission before your lordship is that
Yes.
in cases of departmental inquiry, the strict rules of evidence as regards proof of act date would
These are
not
both judgments pertaining to Ds.
Lordship.
Both judgments pertaining to departmental inquiry,
Yes.
Supreme Court judgments. Therein, it has been clearly held that to prove the documents, someone has to step into the witness box. Unless those documents are such which are kept or maintained in ordinary course of business.
But in a case where the delinquent employee, he makes an unqualified admission with respect to the document.
All right,
In
read,
that case.
read. Read your findings which you want to read. Yes,
Lordship, I will quickly summarize the basic formulations of my
Yes.
argument first.
sure.
Lordships had heard me on the article of charge number 3.3.
Yes,
With respect to that particular charge, which is basically with respect to impersonation,
yes,
the bank has relied upon certain documents which are account opening forms and withdrawal voucher.
yes,
And those were confronted with the delinquent employee. He makes the qualified admission with respect to those documents. He does not distinguish between the document and its content. I will read that part later on.
read, please.
Yes. And once those documents are admitted into the evidence, the only finding of fact which is required to be arrived at, it is whether
Read the charge, article of charge number 3. 3.1,
no, 3.1 is not true.
then
It's 3.3. Your Honor.
3.3, read.
Your lordship will find at page 107. This is the report of the inquiry officer, 107.
Is there in page number 5 of the judgment?
Ma'am.
Impugned judgment.
Ma'am.
And point out how these allegations would normally be proved as a common man understands.
Lordship, page number 84, which is article of charge number 3.3, there were altogether 19 instances.
Yes,
Out of those 19 instances, the presenting officer, he himself had left out 17 of them.
17.
17 of them, he has himself left out.
So which are the two?
Only serial number 2 and 16. Serial number 2 is at page 84.
Two. All right.
Signature of the borrower Uddin of account number so and so, tally with account number so and so and so and so. The borrowers have claimed that they have not signed the documents and
Okay.
forms of.
Borrowers have claimed.
Yes, I admit that there is no oral evidence with respect to the borrowers. They have not been examined.
Okay.
That is there.
Yes.
But if the charges are borne out from the records themselves, and the inquiry is being held by an inquiry officer who is a senior official of the bank, he's competent.
That is not at all material. These are cases when there is a dispute regarding signatures. Your charge itself says borrowers have claimed they have not signed the documents and withdrawal forms. Who else could prove it? Let us know.
No, what I'm saying is that if the documents themselves bear out the charges with respect to the signature, what I'm submitting before your lordship is if the inquiry is being held by.
When the charge should read like that, the document itself establishes that the signatures are not of the borrowers.
What I'm saying is that the inquiry officer is competent to compare the signatures, their similarities and dissimilarities. That is the observation of the Supreme Court in the.
All right, read that finding. Read that finding. The inquiry officer has concluded this manner.
Yes, your lordship.
Read. Charge number 3.3.2. Yes. Point 2 and point 16, they are similar. Read the findings. And you said that it is an admission. It's a denial, page 87. 3.2.
No, in the inquiry proceedings, your lordship, there is a specific admission regarding their authenticity and genuineness.
Read page 87, please.
87, this is a
3.2.
3.1, 3.2, 3.3, these are omnibus denials, your lordship.
Yes, so
During the inquiry, what I'm saying is that during the inquiry, lordship will kindly come to page 203, which is the inquiry, the relevant portion of the inquiry proceeding.
all right. 203.
203 of the appeal memo.
Okay. Read, please.
In the middle of the page, lordship will find the management exhibits marked as so and so are handed over to the charge officer, which are submitted by the presenting officer.
Yes.
The inquiry officer to the charge officer, please go through the above documents which are handed over to you regarding the authenticity of the documents presented to you. I received all the documents duly verified
Yes.
by the presenting officer, and I accept the authenticity of all documents submitted to me in regular
Okay.
hearing number so and so.
Yes.
Now, in this particular case, he was the branch manager at the relevant point of time during which those accounts were opened. Now, he does not deny that those account opening forms are with respect to the period when he was the branch in charge.
Yes.
He was the branch manager.
All
Now,
right.
the only finding of fact which is required to be arrived at is the similarities or dissimilarities of signature. And
Gentlemen, the account opening forms and the withdrawals,
Yes.
they are under the same signature.
not under the same signature. Lordship will kindly see. These are
That is what the charge is.
no. The charge is that these are account opening forms with respect to different persons. But one person who is the impersonator, he has signed on behalf of all these persons.
Sorry, this is not the charge. Read again. Read 3.3.2. Yes. And this admission is only regarding documents being genuine. How does it make a difference? He doesn't admit that the signatures are not of the person who opened the
He does not,
account.
he doesn't deny also. He makes an unqualified admission. He does not make any denial with respect to the contents of the document.
Is the question framed in this manner that the signatures are not of the person who purportedly opened the account form? Where is that question?
Your Lordship.
Where is that question to the charged officer?
So the question is with respect to the documents, but he is free to make a comment upon the contents.
Why should he? Unless you make that allegation.
He knows the contents.
Settled law is that the prosecution or the department has to stand on its own legs.
With respect to departmental inquiries, Your Lordship, the standard of proof is only preponderance of probabilities. It is not beyond reasonable doubt.
Excellent. All right, carry on. You mean to convey that the documents speak for themselves, right?
No, what I mean to
Then-
say is that once the documents are admitted, the only part which is required to be found out.
Why was the bank manager required to deny the original bank account opening forms? Why was he required to deny? What would he have gained out of that?
No, he would anyways be required to admit or deny because we cannot rely upon any document just like that. These have to be
Mr.
confronted. with
Council,
the
these are
detail.
bank account opening forms.
Yes.
There's no question of denying that. Your charge is these were not opened by the person whose name is reflected in the form.
Yes.
How do you prove that fact? Let me know. Let us know. From the admissions, all right, come from the admissions. How do you prove these facts?
Your Lordship would kindly allow me to refer to the citation.
Read your findings first, Mr. My friend,
Yes.
on the facts. Read your inquiry officer's findings. Read. Yes.
The inquiry officer's finding with respect to Article 3.3 is at page 111.
Triple.
111. Prior to that, he has examined the case presented by the presenting officer and the charge officer, and the finding is at the.
Has the presenting officer put any question to the CO that the documents on which you place reliance bear the 4 fabricated signatures of the person in whose names the account was opened? Please read out that question.
No, he cannot ask that question because he is not a witness to the act of impersonation.
Okay.
It is
very well.
basically a charge relating to negligence.
So who is
He
the
did not
witness?
ensure.
Who is the witness to the charge of impersonation?
No, there is no witness. There is no witness. What I'm saying is that if the
Very well. You carry on, you argue in your own
Yes.
way.
Lordship will kindly see page 1, the observation of the inquiry officer.
Yes.
I have observed that the PO has failed to present the cases convincingly. In respect of serial numbers so and so 1 to 17, except 2 and 16, he has himself found it difficult to recommend the charges for considering as proof. These are the instances which he has left out. The presenting officer has left out. However, in respect of irregularities reported under serial number 2 and 16, the documents produced and the argument placed by the PO have been found.
Now, where is the argument placed by the PO?
Yes.
Read.
Yes, Lord. Lordship will find it at page 257.
257.
257.
Yes.
257, at the bottom portion, charge number 3.3 starts. The first one is the instance.
This is the inquiry report.
No, this is the presenting officer's argument.
Argument. Where is the inquiry report?
Inquiry report is at page 102.
102. You are reading this 111 is part of the inquiry report.
Part of the inquiry report.
Okay.
Before that, your Lordship will kindly see the presenting officer's argument.
Yes.
Yes. Page number 258, the relevant portion you
Yes.
Lordship will find. The charge is that in signatures of the borrowers in account number, these 3 account numbers, the word Uddin is same and signed by one person.
Charge is that.
Yes, charge is that because there is a common surname because of which this particular impersonation could
This is charge number
3.3. 3.3 serial instance number 2.
Okay.
The charge is that.
Let us read the charge again. Page number
Yes, 84. Your Lordship.
84. Yes.
Signature of the. I'm sorry. Signature of the borrower Uddin of account number 88971 tally with the other 2.
Yes.
The borrowers have claimed that they have not signed the documents and withdrawal form to cases. That is the charge.
Yes.
They have a common surname, which is Nijamuddin, Najimuddin, and
Okay.
If we come back to page 258.
Yes.
In support of this charge, I have submitted documents ME 75, 76, and 77. When I went through these accounts, I found that the signatures of the borrowers in account number so and so were Uddin word tally, and same person had signed in both the loan documents and withdrawal. Therefore,
Yes.
I request you to consider the charge as proof. This is
Okay.
serial number 2 and 6.
This is the conclusion of the PO.
This is the
Right.
conclusion of the PO. And this
No,
argument. was
just hold on.
And serial number.
Just hold on, Mr.
Oh,
Counsel.
I'm sorry, I didn't hear you.
This conclusion, the PO gives on basis of his own observation.
Yes.
Does the CO get an opportunity to cross-examine the PO on this point? This is his conclusion drawn on the basis of his experience, right? The signatures are same. Any opportunity to the CO to cross-examine the presenting officer? He assumes the role of a witness, who's expert witness, saying that the signatures are same. Okay? Where's the opportunity to cross-examine?
He was there to comment upon the evidence. He was there. Because if.
Gentlemen, this is a conclusion of the PO,
Yes, Your Lordship.
okay? Which is adverse to the interest of the CO. So whether the CO has a right to cross-examine him on that, on that.
If the document itself is uncontroverted, then the question
Please
of.
don't even try to raise that argument. The document is uncontroverted because it is part of the bank record. But the document itself would not speak that the signatures are same. There has to be some person who says so. Or an expert report which says so.
The expert report, in my humble submission, would not be required in the
So,
department.
all right, a person who is your PO says so.
Yes.
He is the witness. He is the only person who concludes that the signatures are same.
The inquiry officer can base his finding upon the document itself. Because he being a senior bank official. it's
Okay,
competent enough.
now let us know, what is the charge number 3.3 based on? What is the substance of that allegation?
The substance of the allegation is that one particular person who is an impersonator, he account these 3 accounts in the name of 3 different persons.
The
and he
borrowers
signed.
claimed.
Yes.
That is what the basis of the charge.
Yes.
What prevented you from calling the borrowers in evidence?
There is a particular portion in the inquiry proceedings. The borrowers who had claimed that they had not actually opened the accounts, they were sought to be produced, but they did not turn up. That is as far as the fact.
Okay, very well. Okay. So your case is that as the PO has concluded that the signatures are same, so the charge is found proved. That's right.
No, my submission is that
Yes.
once the PO has made his argument and the inquiry officer makes a finding based on his experience with regard to similarities and dissimilarities of signature.
All right.
he's-
Let's read the finding of the inquiry officer. That he himself compared the signatures and came to this finding. Read.
Page 111, madam.
Yes.
Nothing.
Yes. Let him point out.
No, he has said that in respect of irregularities reported under serial number 2 and 16, the documents produced and the argument placed by the PO have been unacceptable.
So the findings of the inquiry report, the disciplinary authority says, I agree with the findings. Is that acceptable? Where's the independent application of mind?
In my submission, Your Lordship, this would cover the arguments which were placed, and if they have been accepted, detailed reasons would not be required.
Gentlemen, the finding on signatures being the same is not recorded by the PO. He simply makes an argument, right? So it is my submission that the signatures are same.
Yes.
Who is to draw the conclusion?
Because that is the only finding which the inquiry officer can arrive at. There is no other finding to arrive at by the
Okay,
inquiry officer.
very well.
Kaushik, I will just quickly refer to the judgments which I would like.
This is on 3.2 and 16. This is the only conclusion on which you bank upon, right?
Yes.
Okay, very well. Now you may cite the judgments. Read, please.
Lordship, I've highlighted the relevant portion. Lordship would find it at page 8 of the printout.
Yes.
1964, AR 1964, Supreme Court 264.
Yes. Read. Carry on.
That takes us to the merits of the respondent's contention that the conclusion of the appellant that the third charge framed against the respondent had been proved is based on no evidence. The learned Attorney General has stressed before us that in dealing with this question, we ought to bear in mind the fact that the appellant is acting with the determination to root out corruption, and so if it is shown that the view taken by the appellant is a reasonably possible view, this court should not sit in appeal over the decision and seek to decide whether this court would have taken the same view or not. This contention is no doubt absolutely sound. The only test, Lordship, this is with respect to the basic principle I'm relying on.
Yes.
The only test we can legitimately apply in dealing with this part of the respondent's case is there any evidence on which a finding can be made against the respondent that charge number 3 was proved against him?
Yes.
In exercising his jurisdiction under Article 226 on such a plea, the High Court cannot consider the question about the sufficiency or adequacy of evidence in support of a particular conclusion.
Yes.
That is a matter which is within the competence of the authority which deals with the question.
Right.
But the
But
High
of
Court,
the
but
High Court can definitely examine
yes,
the availability or otherwise of the evidence.
Yes, the later part of this, the same very paragraph.
Yes.
This approach will avoid weighing the evidence. It will take the evidence as it stands and only examine whether on that evidence the impugned conclusion follows or not. Applying this test, this is the finding with regard to the fact.
Yes.
The second judgment, I'm placing your lordship, it is of a division bench of our.
How does it help you, sir?
Lordship?
How does this judgment help you? This is a case of weighing the evidence.
Yes.
The present one is a case of no evidence. How does this ratio of this judgment help you?
It cannot be a case of no evidence because these particular documents were there.
It is not our job to convince the council. Carry on.
They were executed and they were accepted as regards the.
Okay, next judgment, please.
Lordship 2013 2 GLT 785.
Yes. Yes.
This is a similar case where the documents were admitted into the evidence and no oral evidence was left with respect to the
Yes.
documents. Paragraph 19 onwards, Your Lordship. It has been contended on behalf of the petitioner that the inquiry suffered from serious lapse of procedural requirement, inasmuch as no witness was examined by or on behalf of the disciplinary authority, and the relevant document, namely the TA bill in question, was not formally proved at the inquiry. It is, however, not in dispute that apart from the list of witnesses, a list of documents had also been submitted by the petitioner, which included the TA bill in question. While considering the above contention of the petitioner, it is of utmost importance to note that the contents of the TA bill in question were never in dispute, in the sense the petitioner had all along admitted that he had submitted the TA bill for the period from so-and-so to so-and-so. And he rectified his bill by claiming the TA bill from so-and-so to so-and-so. It becomes therefore crystal clear, notwithstanding the fact that the TA bill in question had not been exhibited or proved in the inquiry by any officer on behalf of the disciplinary authority, the contents of the TA bill in question remain undisputed. In the circumstances as indicated above, no prejudice can be said to have been caused to the petitioner. In fact, to a pointed query made by this court, nothing could be submitted on behalf of the petitioner to show that the petitioner suffered any prejudice because of the fact that the TA bill in question had not been formally proved by bringing in any witness. A disciplinary inquiry, one bear in mind, is essentially an inquiry for the purpose of determining the guilt or otherwise of the employee who is proceeded against. The procedural safeguards are required to be adhered to so that no prejudice is caused to an employee who faces the inquiry. What an inquiry therefore requires is fair play and transparency and not technical adherence to relevant rules. In the case at hand, there was no prejudice caused to the petitioner and therefore no miscarriage of justice took place. The lapse on behalf of the disciplinary authority to examine a witness for the purpose of proving the TA bill in question cannot be considered so serious a lapse that it can be held to have rendered the finding of the inquiry officer not sustainable anymore. This apart, the finding of the inquiry officer can by no means be regarded perverse inasmuch as gross sufficient cogent reasons have been assigned in support of the conclusion which the inquiry officer has reached.
Right.
While considering the question as to whether the failure to bring a witness to produce the TA bill in question was so serious a lapse on the part of the disciplinary authority that it rendered the finding of the inquiry officer not sustainable. It also needs to be noted, if we may reiterate, that the TA bill which forms the subject matter of inquiry was never in dispute, inasmuch as the petitioner admitted that he had indeed submitted the TA bill in question. What the petitioner had contended was that he had made a mistake in mentioning the date so-and-so, and the mistake was unintentional and bona fide. The only question, therefore, which remained to be answered by the inquiry officer, as already mentioned above, was whether the TA bill, which the petitioner had submitted claiming so-and-so, was false.
Okay.
This apart, at the time of inquiry, the tour diary was asked for by and furnished to the petitioner, and hence there is no scope to contend that the petitioner suffered from any prejudice. Moreover, and as has been already pointed out above, the petitioner adduced evidence by examining 3 witnesses. No prejudice or miscarriage of justice can therefore be said to have been taken place when the petitioner has miserably failed to show as to what prejudice, if any, has been caused to him by not examining any witness, when the contents of the documents which give rise to the disciplinary proceeding against him remain undisputed, unchallenged, and not denied by him. The learned tribunal therefore committed no error by refusing to interfere with the proceeding which culminated into the penalty.
Okay. Yes.
The factual situation of this case is also that the documents which were relied upon by the inquiry officer, by the department, they were not exhibited by way of
Nature of documents is relevant, Mr. Counsel.
not proved by way of oral evidence or by formal way of so. AR 1998 Supreme Court 2592.
Yes.
Paragraph 11, 12, and 13.
Yes.
The second objection is equally meaningless. The documents were taken on file during the course of the inquiry, and the first respondent perused every one of them before the conclusion of the inquiry. Copies were also furnished to him, and as requested by him, he was given 7 days time for presenting his defense after the receipt of copies of documents.
Yes.
Though under the rules, only 3 days time was permitted.
Yes.
Instead of giving numbers to the exhibits as and when documents were taken on file, the inquiry officer would appear to have given serial numbers to the exhibits at the conclusion of the inquiry. The adoption of such procedure by the inquiry officer was not violative of the principle of natural justice. 12 is not relevant for our case. Paragraph 30. The objection that the certified copies of the assessment register should not have been marked without examining the concerned officials of the municipality is untenable. The genuineness of the document was never in dispute. Here, follow the
Yes.
Director General Indian Medical. This is a slightly longer judgment. This cites all the other judgments rendered on this point till now. 2021, 11 SCC 321. The
Yes.
relevant portions your lordship would find from page 9 onward.
Yes.
The non-examination, the issue is the non-examination of the particular witnesses with respect to the charge. Paragraph 21, a 3-judge bench of this court and so, 1977 2 ACC was dealing with the issue of non-examination of passengers when the allegation against the contractor was non-issuance of tickets. This court held that in domestic inquiry, strict and sophisticated rules of evidence under the Indian Evidence Act may not apply, and that all materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence, provided it has reasonable nexus and credibility. This court held as under. I will not read the whole quoted paragraph. Paragraph 4 has been quoted. It is well settled that in a domestic inquiry, the strict and sophisticated rules of evidence under the Indian Evidence Act may not apply. All materials which are logically probative for a prudent and mind are permissible. There is no allergy to hearsay evidence, provided it has reasonable nexus and credibility. Line about 10 from below, if your lordship can find the portion I'm relying upon. The simple point is, was there some evidence or was there no evidence? Not in the sense of the technical rules governing regular court proceedings, but in a fair common sense way, as men of understanding and worldly wisdom will accept. Viewed in this way, sufficiency of evidence in proof of the finding by a domestic tribunal is beyond scrutiny. Absence of any evidence in support of a finding is certainly available for the court to look into because it amounts to an error of law apparent on the record. In 2015, 2 SCC, the Honorable Court laid down the broad parameters for the exercise of jurisdiction of judicial review. The High Court can see only whether the inquiry is held by a competent authority. The inquiry is held according to the procedure prescribed in that behalf. There is violation of the principles of natural justice in conducting the proceedings. The authorities have disabled themselves from reaching a fair conclusion by some considerations extraneous to the evidence and merits of the case. The authorities have allowed themselves to be influenced by irrelevant or extraneous considerations. The conclusion on the very face of it is so wholly arbitrary and capricious that no reasonable person could ever have arrived at such a conclusion. The disciplinary authority had erroneously failed to admit the admissible and material evidence. The disciplinary authority had erroneously admitted inadmissible evidence which influenced the finding. The finding of fact is based on no evidence. Under Article 226 and 227, the High Court shall not reappreciate the evidence, interfere with the conclusions in the inquiry in case the same has been conducted of the evidence, go into the reliability of the evidence. Interfere if there be some legal evidence on which findings can be based. Correct the error of fact, however grave it may appear to be. Go into the proportionality of the punishment unless it shocks its conscience. In 1995 6 SCC, the Honorable Apex Court held, it was held that the power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of the court. The judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. The court is to examine as to whether the inquiry was held by a competent officer or whether rules of natural justice are complied with. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is concerned to determine whether the inquiry was held by a competent officer or whether the rules of natural justice are complied with. Whether the findings or conclusions are based on some evidence, the authority entrusted with the power to hold inquiry has jurisdiction, power, and authority to reach a finding of fact or conclusion. But the finding must be based on some evidence. Neither the technical rules of Evidence Act nor of proof of fact of evidence as defined therein in the Evidence Act apply to disciplinary proceedings. When the authority accepts that evidence and conclusion receives support therefrom, the disciplinary authority is entitled to hold the delinquent officer is guilty of the charge. The disciplinary authority is the sole judge of the facts where appeal is presented. The appellate authority has coextensive power to reappreciate the evidence or the nature of punishment. In a disciplinary inquiry, the strict proof of legal evidence and the findings of that evidence are not relevant. Adequacy of evidence or reliability of evidence cannot be permitted to be canvassed before a court or a tribunal. And the last para, Your Lordship, 2005 7 SCC, this was quoted. The Honorable Court held that the degree of proof which is necessary to order a conviction is different from the degree of proof necessary to record the commission of delinquency. In criminal law, burden of proof is on the prosecution, and unless the prosecution is able to prove the guilt of the accused beyond reasonable doubt, he cannot be convicted by a court of law. In a departmental inquiry, on the other hand, penalty can be imposed on the delinquent officer on a finding recorded on the basis of preponderance of probability. The next judgment is, in fact, a judgment which was referred to by Your Lordship on the last occasion. So that's some paragraphs of it I'm relying on. 2000 AR 2013 Supreme Court 90.
Yes.
Party naam to
Narendra Kumar Pandey, State Bank of India. This was, of course, in the case of ex parte inquiry.
Yes.
We are of the view that the High Court also committed an error in holding that since no witness was examined in support of the charges, it was a case of no evidence. In an ex parte inquiry, in our view, if the charges are borne out from the documents kept in the normal course of business, no oral evidence is necessary to prove those charges. When the charge officer does not attend the inquiry, then he cannot contend that the inquiry authority should not have relied upon the documents which were not made available or disclosed to him. In our case, the documents were made available and he admitted them. Of course, even in an ex parte inquiry, some evidence is necessary to establish the charges, especially when the charge officer denies the charge. Uncontroverted documentary evidence in such situation is sufficient to prove the charges. The inquiry authority has examined each and every charge leveled against the charge officer and the documents produced by the presenting officer and came to the conclusion that most of the charges were proved. In a departmental inquiry, the disciplinary authority is expected to prove the charges on preponderance of probability and not on proof beyond reasonable doubt. Reference may be made to two of these judgments. The documents produced by the bank, which were not controverted by the charged officer, supports all the allegations and charges leveled against the charged officer. In a case where the charge officer had failed to inspect the documents in respect of the allegations raised by the bank, in this case, he has inspected and admitted and not controverted, it is always open to the inquiry authority to accept the same. Although it was in case of an ex parte inquiry, what I would propose before your lordship is that a principle which is generally impermissible as a proposition of law, it would also be permissible in a case of ex parte inquiry. But since this proposition of law.
Every of the judgments you have cited, each judgment says evidence is required, right? No, we don't need to grill it into your mind that there is no evidence. You just can't dispute this situation. Or that's all. Thank you.
Two more judgments, one more judgment I'm relying on.
Judgment, Mr. Counsel, we need not read every judgment which is not even close to the mark. None of these judgments are in any manner applicable to the facts of this case. Thank you.
It is only aspect of the inquiry officer's competence to discover the similarities or dissimilarities of signature. If your lordship does
Mr.
not need to
Counsel,
read it, I will
is there a finding of the inquiry officer? Read that finding. We asked you. Have you been able to point out that finding? Then we read the judgment.
I will not read it. I will not read the judgment. I will
Read the
read it.
finding of the inquiry officer regarding the similarity or dissimilarity of these signatures.
That is not definitely specific.
Then why the judgment is to be cited? Why you want to waste the time of the court? Just because you have made a research, every judgment needs to be referred. It's really strange. Yes,
So that leaves us with charge of the article of charge number 4.
yes,
Which is the last charge I'm relying upon.
okay.
Out of the
That has been found proved?
yes, 3 charges were found to be proved.
Yes,
One
charge
of
number
those-
4.
One of those charges we already left out.
Yes. $6,44,000
Yes, Lord.
suspicious transactions.
Yes.
Yes. What is the finding on this charge?
Page 111, my lord, same inquiry report,
Same.
my lord. Page 111.
Read, please.
Charge 4. The charge against Sri C.R. Das is that cash deposit transactions to personal accounts in different dates are suspicious in nature.
Yes.
According to the PO, the transactions are not out of his own known source of income as the salaried person. These are disproportionate to his salary in ME 126. Therefore, he requested to consider the charge as true. In defense, this is the defense of the charge officer. The charge officer has submitted that the allegation is not based on fact. He has further informed that even the PO is aware of it. He lives in a joint family consisting of his 4 unmarried sisters and his wife, who are all employees in the state government. They all earn handsome salaries. They
Yes.
wanted to construct a house by demolishing our ancestral house, for which his sisters and his wife pooled their savings and deposited the same in his account,
Yes.
so that the payment to the vendors can be made in a systematic manner, and making such payments to the vendors help in getting cash discount. This can be verified by our good self. In view of the above, I pray to you that the charge be considered as proof. Now, the finding is, I have observed that some of the transactions are disproportionate to the known sources of income of Sri Das. Although he has mentioned that 5 other members of their family.
Whether the known sources of income have been accounted for in this finding? What is his salary? What are his savings? What are his withdrawals? Where are those statistics?
No, it has been proved by way of ME 126. These are disproportionate to his salary income. There is a particular document.
Where is that salary statement in this inquiry report?
No, that would be part of the documents. Your Lordship. It could be in a different.
Inquiry officer is not supposed to give a finding, return a finding that his income over a period of time was so much, whereas the amount is disproportionate to what salary he has drawn for the same period. Is he required to record that finding?
The delinquent officer does not dispute the disproportionality.
Okay,
He
Very well.
admits.
right.
He admits that these are disproportionate, but these are basically
Okay.
deposits made by his unmarried sisters and
Yes.
wife. But the problem is that he has not adduced any documented evidence in support of the same, because
Yes.
he has, Lordship will kindly consider one.
Yes, yes.
The delinquent employee has examined 5 defense witnesses. He has examined 5 defense witnesses who were borrowers in
Okay.
respect of article of charge number 1.
Right.
If this particular defense is actually true, then his own unmarried sisters and wife should have been adduced.
That's right. This is right. Yes.
He does not dispute the fact that these deposits are disproportionate to his known source of income. That is not his defense. His defense is that these are pulled from the income of his unmarried sisters and wife.
Yes.
Once he takes his defense, the onus shifts to him to substantiate the same by way of documentary evidence or oral evidence. If in respect of article of charge number 3.3, if I am held up, the same principle will also apply to the delinquent officer.
Yes. Because he has deposited this amount of 6,44,000 over a period of 1 year, less than a year, 11 weeks or 11 months only. Yes.
And whereas he has examined 5 witnesses who are foreign to her.
Yes.
His own family members could have been examined very well.
Yes. What is the finding of the unit single judge on this on this charge?
Lordship will kindly come to page 349.
Is para?
It starts from page 348 down below, paragraph 32.
Yes.
Similarly, while holding charge proved as regards charge number 4, that the accused has disproportionate transaction to his own source of income, requisite data such as his monthly income, allowances, deductions, areas, etc., known source of income has not at all been shown in the chart so prepared, as has been mentioned above. Which again,
Can you read his statement in relation to charge number 4? Statement of the CO.
Statement of the CEO, yes, Your Lordship.
Read, please. Where he says that these are my family members.
Yes, yes.
Let us see.
The brief of the charge officer is at page 88 and the relevant portion.
Charge number 4.4. 4.
Only 4, Your Lord.
Yes.
Page 91 is the relevant page where he has made his submission with respect to charge number 4.
Just let's see. Page 87 is the reply.
Page 87 is his
Written
brief.
reply.
This is written brief, you know.
Yes.
And page 91 is charge number 4. The allegation is not based on facts. It is pertinent to inform you that even the PO is aware of it. I live in a joint family consisting of my 4 unmarried sisters and my wife, who are all employees of the state government. They all earn handsome salaries.
Yes.
I did not want to say this, but the circumstances have compelled me to say this. We wanted to construct a new house by demolishing our ancestral house, for which my sisters and my wife pooled their savings and deposited the same in my account so that the payment to the vendors can be made in a systematic manner as making cash payment to the vendor. It is exactly the same statement which was reiterated by the inquiry officer in his mind.
Yes.
This can be verified by your good faith.
Yes. Yes. Okay, very well. That's all.
With respect to charge number 4, that is.
So these are the only 2 charges, 3
These are the
charges.
only
from
2 charges.
Yes, very well. What do you say, sir? Charge number 4.
Yes.
How does the finding of single judge stand to scrutiny?
Well,
There are 32. No finding at all. This is something which is serious. Deposit of 6,50,000 odd over a period of 11 months, which you say came out of salary of your own relatives. Where are those relatives? Where are their account statements, withdrawals? It's an admission that it's not out of your own income. So, public servant amassing a sum of rupees 6.5 lakhs over 11 months, claiming that these are out of the proceeds of his relatives' salaries. How is it to be proved?
May I submit from a perspective?
Sure, definitely.
Your lordship is the charges. As far as the charges are concerned, that is in respect of negligence on my part with regard to my lordship procedure.
Those charges are of different nature. Borrowers, account opening, those are entirely different nature. This charge directly deals with misconduct of a public official. As a matter of fact, a criminal case under section 13(1)(d)(2), as it earlier stood, should have been registered against him. You are given the opportunity to explain, to prove it, or to defend it by leading evidence. What evidence if you like?
Now, my lord, my submission is, your lordship will see, my lord, under charges.
Yes,
There is no charge, my lord, that I have misappropriated bank's money.
forget about it. DA, nothing is required. The entire burden to explain what are the sources of that money is on the DO, a delinquent officer.
Now,
Explain.
yes, my lord, my submission is, so far as the third code is concerned, it is mutually exclusive with the other charges.
Yes, it is. Assume.
Now, my lord, the moment other charges go,
Yes,
my lord, my explanation in chart number 4 remains. Because,
explanation.
yes,
All right, we see your explanation, whether it is acceptable. On what basis do we find that explanation to be substantiated? Tell us.
well, had it been a case
Yes.
that my lord, I have misappropriated bank money by depriving my lord, the beneficiary of the
In a
loan
DA
amount.
case, misappropriation is not required to be proved. It is a self-speaking charge. That amount stands out. And the amount requires an explanation from the officer. Where did it generate from? If it is no explanation, there's a presumption of misappropriation. Consequential finding comes out on its own.
My lord, local agency, had it been an investigating agency, either my lord, under the, my lord, the PMLA Act or some other authority, who could have, my lord, inquired into the illegal
They are
proceedings?
not required to. The proceeds are there in your account.
Because your lordship will kindly see. My lord,
Yes.
my submission is, there is no charge to the effect that I had misappropriated.
Just
bank
now
money.
you said it's a standout charge,
Yes, my lord.
right?
Yes.
A charge in itself, which is sufficient to send you out of service.
Out of service, had it been a case, my lord, that was proved.
Charge number 4 is not proved.
Well, in my respectful submission, my lord,
What-
I have,
What more proof is required other than to present your bank account over a period of 11 months?
these are not bank account. This is a
Statement. You are not denied that.
Yes.
You try to give a feeble explanation, a lame one at that. What more do they require in form of proof for this charge? Documents kept in course of business. That is your statement of account. That shows 6,44,000. Burden is on you. Inescapable conclusion. Even if we don't accept their arguments, qua 3.2 and 3.16, this is unassailable. This charge is unassailable.
I have said it, that I have received from my.
Yes, Barley statement, as it was there, Barley statement, which is not to be accepted. Same in this charge, your Barley statement can't be accepted. If you don't have any explanation, brother, no defense at all to this charge.
No, that is my case because there is a no charge, independent charge regarding misappropriation of money.
Is it necessary? Tell us from any judgment. Is it required? In a case of DA, the charge of misappropriation is sine qua non. Let us know. Any proposition of law? Educate us on this.
Because my lord, had it been a case that it has been proved on the part of the my lord disciplinary authority, then the onus will keep on me. then perhaps, my lord, I would have required, it's my understanding, my lord. But here, since, my lord, I have given an explanation, cogent explanation, my lord.
Cogent.
Yes.
How is it a cogent explanation?
And, my lord, that has not been, if your lordship sees how it has been dealt by the disciplinary authority.
Yes, disciplinary authority says no evidence.
No, disciplinary.
Only bald.
Not say that. Disciplinary authority says.
Yes.
Suspicious in nature.
Read.
Yes, my lord.
Read.
If your lordship comes to the order of the disciplinary authority.
Read, please.
Yes.
Page
Page number 118.
118.
Yes.
Read.
If you firstly lordship comes to the, my lord, findings of the inquiry report. This is a triple one.
111. Yes. That we have read.
If your lordship comes to the order of the disciplinary authority at page 118.
Yes.
Charge 4, EO has stated the charge as proof, as the EO has not submitted any documentary proof and his statement is not supported by any acceptable authentic document. In
Yes.
this connection, he has to state that his discharge is based on fact. It was a true and honest submission on his part, purpose of which the money was deposited in the account also genuine. If he would have accumulated the money by using unofficial means, ethical, he would have opened the account in any other bank and would not have exposed himself to such valuable situation in the name of law and natural justice. Now, the lordship is ongoing through the charge sheet, records of inquiry report.
Where are you reading from?
Charge number 4. Sorry, charge number 40 is 119.
Yes.
119. From material exhibit 128, that is, my lord, the list, my lord, the chart table. It is observed that the cash and transfer transaction in the account as mentioned in the chart sheet are beyond his known.
There is no dispute.
And are of suspicion.
This is your admission. You offered an explanation which you could not substantiate. What else is the finding to record return?
Thus, the contention of the draft cannot be accepted, looking into the seriousness. Now, my lord will kindly see.
Yes.
Here, they have proceeded on the basis of, they say that some transactions are of suspicious nature. That is the charge number 4. The lordship comes to the charge. So they say that those are suspicious in nature.
Sir, read charge 4, please.
Yes, please.
Read.
Charge 4 at page 78.
Yes. Not related to his salary or any other source of income.
Yes. Page 86 follows the statement of allegation.
Yes.
The following cash deposit transactions in the personal account of the DAS are of suspicious nature.
Yes.
As these entities do not
Relate to his known sources of income. Precise charge. The account entries are there. The total is given out. The period is there. What more specific charge do you want?
In this case, the lordship gives me another someday.
No, sir. Absolutely no. Big no.
Because
decision you may file,
yes,
you may present it to the court of sir with a written note.
That is the case which says, my lord, that proof cannot take place of, my lord, the suspicion cannot take place of proof.
Yes.
There is a judgment to this effect, my lord.
In this charge, the suspicion is on you. You will have to prove. This is a case in DA, there is a reverse burden of proof. Because only you know where from the money came.
Correct.
Then 106 would apply even to a disciplinary inquiry. How have you disproved this charge? That is the core question. You give your judgments, whatever you want. Arguments or judgment reserved. We're escaping that conclusion. Yes.
My apologies to your lordship if I've overstepped my.
No issues, no issues. You have a vested interest in your client. Yes. Arguments or judgment reserved. You may give the list of citations, both of you.
I've submitted it.
Yes. Look at the list.